Okay, so we're here for the Village of Armada Planning Commission training and ZBA and DDA. So I'm going to turn it over to Amy Neary from McKenna and Associates.
Hi, for those of you who don't know me, I'm Amy Neary from McKenna Associates. I'm a senior principal planner, and I've been working with the village for probably 2-3 years, maybe more than that now. Time flies when you're having fun. And so I'm going to be here giving you basically an overview of the roles and responsibilities of the boards and kind of in some of your functions, and then go into some specifics regarding the DDA and some of the things that the Planning Commission does on a regular basis, and how to help you guys position yourself to make sound decisions and defensible decisions in the future. So some of this, just to give you an overview, might be something that a lot of you have heard or been trained in before, and it might be newer for some of you, but it's kind of always a good refresher for those of you who may have even heard it before. So why do we plan? Why did we just go through that process and finally, after all that time, adopt a master plan for the village? We do that for several reasons: to anticipate change in the community, to ensure wise uses of our resources. We're only given so much land within our boundaries, and make sure we do the most with it. We only have so many natural features and so forth. To implement a vision for the future. Part of the master plan process that we just recently went through, the Planning Commission went through and looked at goals and objectives for the community, and looking at what it is that we want to be in the future. What is it that we want to preserve and keep about Armada, and what is it that we want to change? So coming up with a vision for the future, protecting our environment, and most of all, preserving our quality of life. There are two statutory authorities that give you the ability to plan and zone. The first is the Michigan Planning Enabling Act, and that was adopted in 2008, and the other is the Michigan Zoning Enabling Act that was adopted in 2006. Prior to that, we had in Michigan separate acts for cities and villages and townships in the county. It took a long time, but after a lot of hard work, we finally put that all together into one act for zoning and one act for planning. And it makes my job a lot easier when it comes to things like public hearing notices. It used to be different for everybody, now everyone's the same. Adoption processes and so forth. So those kind of procedural things definitely have made my life easier with the adoption of those acts. The three bodies that we're going to focus on first are the Planning Commission, Council, and the Zoning Board of Appeals. We'll talk about the DDA separate. They are under a different statutory authority and different roles and responsibilities. Even though it will be this body that is the DDA, it is a different statute and a different, kind of a different game that you guys are dealing with in terms of what you're responsible for ultimately and what your authorities are. So with the Planning Commission, we have the master plan, the zoning ordinance, and subdivision plats. Condos, I didn't put that up there, but there are condos too. And essentially your zoning reviews, a new development, any sort of site plan that might come into the community. Council's role is really appointments to the boards. Council appoints to the Board of Appeals and to the Planning Commission. They are also the body that adopts the ordinances. So the Planning Commission creates them, Village Council actually adopts them. They redo the zoning reviews sometimes, depending on the community and, excuse me, what authority is granted to them. And ultimately, council is responsible for the money in the budgets. In terms of the Board of Appeals, they look at things such as variances, appeals of decisions that are made, and then interpretation and other duties that may be assigned to them. In terms of zoning approvals for the Planning Commission, there are essentially, and the ZBA, there are essentially four. You have your special land uses, which by statute is either the Planning Commission, the legislative body, or the zoning administrator. And here I believe it's just the Planning Commission. Do we go to the council for special land uses?
It comes to planning, but we used to have to go to council for final approval. I don't know if we do that now.
We may still, I'd have to double check, and I should have double checked, but
Yeah, I think we still do.
statutorily, you decide, but it has to be one of those bodies. For site plan, again, statutorily, you have the option of it being just the planning commission and council, or, just council, or it could be administrative as well. Here, site plan is the planning commission, as you know that for a fact. Rezonings, on the other hand, is something that's a little different. That is essentially the same as an ordinance amendment, so it is a law, and it must be done, final authority is the council. So the planning commission is responsible for reviewing it and making a recommendation, but it's actually ultimately the responsibility of the council, and you do not have the ability to change that. Same goes for variances, that is the ZBA. Each of these statutes allows for and encourages cross-membership between our boards. This allows for us, and I think this group does a pretty good job at these meetings that I've been at, talking about what's going on at other boards and commissions and so forth. So we encourage that cooperative planning and development in the community. But I would just point out that it is not, sometimes it's required and sometimes it's not. I'll talk about that in a few minutes. But what is important to note in regards to this is your ZBA member that's on the planning commission can only vote once. So if you have an application that is presented to the planning commission and the ZBA, they only have the ability to act on that either at the ZBA or at the planning commission. They have to make that decision. And I think we've had a few, or we've talked about it before in the past. Excuse me, sorry, I'm all distracted. The other thing is, what has not been completely clear, and some attorneys advise the same way, is that when you have an action that requires planning commission and council approval, that representative can only act on the application at one time as well. So that might happen more common here than ZBA and planning commission. So if you have a rezoning or a special use, and the planning commission had the public hearing and made the recommendation, that council representative can only act at one time. They can't act twice or change their vote. That oftentimes what would happen is they would be allowed to change their vote at a different meeting. So, excuse me, why do we need a master plan? The big reason we need a master plan in a community, and why it is called for in statute, is as the basis for our zoning. We have a zoning ordinance that we have in place, and it should be based upon the goals and objectives of our master plan. It should represent the different land uses that we have in our master plan. It should address how development will affect the environment, our infrastructure, and how does it work with the surrounding townships. Our master plan and ordinance do take that stuff into consideration. I would say that since we did just adopt a new master plan, it may behoove us as a commission to go through the zoning ordinance and identify what areas we might want to tweak to make sure it is consistent with our master plan. But generally speaking, our existing zoning ordinance does support the recommendations of the master plan that we just adopted. But again, it wouldn't be a bad exercise to go through it as a commission just to make sure we are on the same page. Oftentimes, there's a lot of confusion, especially by applicants when they come in. What is the difference between the master plan and the zoning ordinance? My site, it says in the master plan it is industrial. Why can't I just put whatever, this industrial use is on my property? Well, it's still currently zoned residential. Or it may be zoned something of a higher intensity, but the master plan calls for a lower intensity use. And how do you deal with that? The master plan, it's important to note, is just a guide. Whatever it says in the master plan is not the law of the village or the township. It is just a guide for you as a commission in making your decisions for your law, which is the zoning ordinance. Your master plan is adopted and by statute can be just a planning commission document. We send it to the council for their input and their authority to review and distribute. They do have the ability to give themselves the right to adopt that document, but statute says it can be just a planning commission document. And it projects into the future, how land should be used in the future, 20, 30 years into the future. So what it says in the master plan doesn't necessarily, and on our future land use map, mean that it should exactly match what our zoning map is today, because things may not have happened or evolved in the community to warrant some of those land use changes. But at the same time, they do relate to one another, and it's important to understand that relationship. The master plan is the physical development of the community. It guides the physical development, like I just said. And what's a great thing about the master plan, since it is a guide, it's able to be changed and modified with new information as you get new data. You know, it's not written in stone. There are the process in place to allow you to amend it and to modify it as often as you like and as much as conditions, you know, warrant the change. Typically, in a community like Armada, we're not seeing, and especially in this time, we're not seeing a lot of development pressure and change to warrant a continuous revision of the master plan. So the one we have will probably serve us well for a while. You know, at least for the 5 years until we have to review it again and determine what we need to do. When we did our master plan, as many of you know, we looked at all different aspects. We looked at transportation, housing, land use, recreation. There was included in there a zoning plan, if you recall. And all this information that's in that master plan should be used as a basis for the town or the village on a regular basis. It is not the intent of that new document to sit on a shelf, but it should be referred to, I would say, annually when the village is preparing their capital improvements program or your budget. Go back to that plan and say, oh, thank you.
I heard that phone.
It's very nice, and I should have it myself. So I'm going to take a sip before I finish. Right. I was like, uh-oh. Now, am I that in trouble for being that late?
Get that right up in the Armada.
Jimmy Sharp brought a bottle of water in on Monday.
Yeah. Call to service.
Nothing like a small town.
All right.
I didn't want to ask anybody in the meeting to go.
That's fine. Thank you. So not only should the master plan be looked at when we're looking at specific zoning things, but like I said, it should not be on the shelf. I would encourage the planning commission and the council to look at it when, again, you're looking at capital improvements in the community. How do those improvements relate to what we had planned in the plan? Does it support what we had planned in our master plan? Obviously, we do look at it. Probably the most common reason we look at our master plan is when we have rezoning requests and looking for a change of use. But there's a lot more stuff in there that we should be referring to it for than just the change of land use. You know, we talked in there about goals for, you know, public facilities. You know, the last one in there, public ways. We looked at ways to plan for new roadways in the community. So that kind of, again, goes into capital improvements. So I think we're most comfortable, or, you know, our first reason to open that book is when we have a rezoning, but I would just encourage everybody to look at it on a more regular basis and kind of get in the habit of that. We spend a lot of time and money on that plan, so we should use it for what it's there for.
A lot of time.
Well, and in this community, a lot of time was spent on it, but it's good. Now let's use it. Just again to kind of show you, oftentimes the community will say to me, well, our future land use map, why isn't it the same as our zoning map? And it shouldn't be. It's okay that it's not the same. And Again, there may be specific sites now that we adopted the zoning or the master plan where we might want to go out there and rezone, because now's the time to rezone it, and you as a community have the right to initiate some of those rezonings. But for the most part, it was projected out into the future. And, you know, it would be more on a demand of how we implement that. I don't think Armada has been or is in the business of going out there and changing people's zoning without them being consulted and being approached and so forth. So we typically haven't done that, but sometimes there is a need to do that, to implement your visions of your plan. But it's okay that they don't match. I just always have to reinforce that. The master plan, and some of this is what instigated the original, I think, look at our master plan that we have, is that the relatively new Planning Enabling Act requires that we review the plan every 5 years. So every 5 years, the Planning Commission, if you haven't done it before that, like I'm telling you, you should look at it at least once a year. At least every 5 years, you need to take it out and look at it and determine whether or not it still is applicable to the community. If there's areas that need to be updated, if the data is still appropriate, or if it's fine and it still meets your needs. When doing that, you should document it in your minutes. There has to be documentation of your review. And any recommendation to change it or keep it the same or whatever you decide should be made to the village council to make them aware of it. There is no formal notification required. You don't have to publicly notice that you're reviewing your plan or doing anything like that, but you do have to just make sure you have a record of it. And I guess the biggest reason I say that make sure you have this in your minutes is that if somebody were to challenge your plan, you wouldn't want them to say that the plan hasn't been reviewed in 8 years. So how does the community even know that this is still their vision? And, you know, then I have a judge throw it out, you know, for that reason, just because you haven't done your annual review, your 5-year review. So you want to make sure that you do this every 5 years, if not more often. The Planning Enabling Act requires 2 new components, and some of you may have gone through a training like this before, or may have even noticed in this most recent master plan that we adopted. But there are new things that need to be included in the act, and that's a zoning plan, which we do have, which requires that we state when we're planning for residential what that means in zoning. You know, does that mean R1, R2? You know, you have to relate the zoning districts to what your land use designations are. If you don't have a zoning district for a certain land use designation, the master plan should identify that new districts need to be created and what those districts should entail. That's different than what we used to have before in terms of a master plan. And you would often find in communities all these different land use designations in their master plan, and then someone would go try to rezone their property and there might not have been a corresponding zoning district ever created for that particular designation, and it kind of often caused confusion on the community's part and the developer's part and so forth. So I think the legislature was kind of like, okay, we need to stop this. It's pretty simple. Tell us what the zoning district should be. The other item, and we hear a lot about this all over right now, is complete streets, meaning that our plan now is required to include information regarding not only streets, but all people who use your streets. You know, bikes, walkers, trails, sidewalks, the whole thing. We have included that information in the Armada master plan. Complete streets, I would point out, is different for every community. You know, a complete street in Southfield is going to be different than a complete street in Armada, in that I'm going to have to address transit, I'm going to have to address, you know, bike lanes and certain different levels of things. So you define as a community what all your users are and then plan for that. So it's not a blanket for the entire state. The other thing that is required now by the Planning Enabling Act is that the Planning Commission has to prepare an annual report to the Village Council. And I hope you guys have been doing this. I think you guys have been doing this. And in that annual report, it needs to include your prior year activities, so what types of reviews you've looked at, if you've made any amendments to your ordinance, if you've worked on any amendments, generally what you've been doing as a commission. And then it should also include in their recommendations about planning and development. So you should include in that annual report if you want to amend the ordinance, or need budget for amending or creating a new plan or whatever it might be in the community training, whatever it might be. But that should be included in your annual report to the planning commission, or to the village council.
We do ours in a two-step. One is a review and one is what we hope to do in the future.
And that's, nobody says it has to be, one, as long as you do it. Do you do it at the beginning of the year? Is that when we do it?
Yeah, we do it at the end of the year, so that we do a year in review and then a year of planning for the year. So what
Around
we'd like
budget
to-
time, I'm assuming, is it
Well,
before?
it's kind of right at the end of the year, and then, so 1 month we usually do the year in review, and the next month we do what we hope to accomplish the current year.
And that's fine, and that meets your requirement. I would also just suggest, too, one thing that I do suggest to a lot of my planning commissions is when you do prepare your annual report, it's nice at that time, too, to bring out your master plan. And if you remember, in the back of our master plan, we had that implementation stuff, and you can kind of go through it and say, oh, we've done this, oh, maybe we need to work on this, kind of just a refresher of things that we decided were important when we did the master plan as projects to work on. So that might be some of the recommendations to council. It's just another way, again, to keep that master plan fresh in your mind. The purpose of zoning and the legislation and why we're allowed to do all of this there's a number of reasons, but they really can be boiled down to these 6 points. To help protect property values, so that when somebody goes in and makes an investment in a piece of property, they can be reassured what will be able to happen in the district that they're in or around them. Some level of assurance of the uses and the requirements of those buildings, and know kind of what they're getting into. The next is to protect natural resources, prevent nuisances. Prevent nuisances in the terms of, what is it really appropriate to have an industrial area right in, in the middle of a residential area that may have outdoor storage and noise and, kind of all that stuff that we know about. Ensure land uses are compatible, prevent overcrowding, and prevent overuse of property. All zoning ordinances, if you open up one for Armada, for Detroit, for anywhere your township, they all pretty much look the same in terms of what's in them. You're going to have your definitions. Everything, definitions often become one of the most important things when we're defending our decisions. What is meant by, in Garden City, we're having an issue over kennels, and what is a kennel? So what is a kennel and what is meant by that? And the first thing you always go to is your definitions. So we want to make sure we define our terms that we use clearly in our ordinances, and that it is what we mean by that term. Our general provisions, that's the kind of stuff like accessory structures and stuff that applies to everybody, not just to one particular district. Then you have your zoning districts, your schedule of regulations, then your specific standards in terms of parking, signs, landscaping, that kind of stuff. And then all ordinances will have a site plan review process, special land use process, and non-conforming issues will always be addressed in zoning, because non-conformity, and I'll talk a little bit about that in a few minutes, is the result of zoning. You only get a non-conformity because of zoning. And then you have the administration and enforcement. This is often a part that people don't really pay attention to, but it is important. How things are processed, if violations are considered a misdemeanor or a civil infraction, what is the process to get enforcement on an application or a site. So these are important. Administration and enforcement is a very important section that often doesn't get looked at until you have a problem in the community. But when you look in, like I said, in anyone's ordinance, you'll have that, as well as the Board of Appeals. The zoning process is also the same in every community. And a lot of it is predicated on statute. But you have that pre-application phase. In Armada, my experience has been it's usually an applicant contacts Ben or somebody and kind of finds out what the zoning is, where to get an application, kind of gather the basic information. Then they submit the application to the community, and then that's where we start doing information gathering as a planning commission, send any notices, and have our meeting, make our decision and implementation. And it's a cycle, again, that you'll find in any zoning process in any community. So the pre-application step is the initial contact with the zoning authority. And I said, here in Armada, that usually, again, my experience has been, they contact Ben and get that information and, where they go, their fees, their meeting dates, and so forth. The only thing I would point out about that is never just try to answer a question from memory, obviously. Make sure you look at the ordinance. I do it all the time. I'll think something was in an ordinance and I open it up and it really doesn't say what I thought it was going to say when I opened it. For some reason, I just had it in my head that was the requirement, and I'm sure it's happened to all of you. So you want to make sure,
More than that.
See? And so you want to make sure when you're doing that, especially on your initial contact with an applicant, that you open the ordinance and give them clear direction in the beginning. This makes the process go smoother. In the beginning, sometimes, depending on the project, you might meet with them. But I would also think that it's important to keep in your files your notes of all the contact that you have had with the applicant. Again, this goes to making sure you kind of helping you build your case and keep record of all your contact with the applicant, if you ever did end up in court or what have you, that you have a clear history of everything that's happened with this application. Then the application gets submitted. The one thing that I would say about that is I think it's so important to accept only complete applications. It's so frustrating for me as a consultant, as I know it is for the Planning Commission, when you get an incomplete application and then the applicant expects you to take action on something and at a meeting you don't have all the information presented in front of you. So it's really important before I think it goes to the commission that you make sure at administrative level or however works best for you, then go through it, whatever, that you have all the information you need before it's actually presented to this body. And application deadlines, I think, are also something very important to withhold and be consistent with everybody. In terms of information gathering, one of the biggest things is a site visit that I think is important to encourage for specific development proposals. But what I would point out is that this isn't your property, so make sure that you have permission to go to the site, written permission from the applicant or the property owner. Group visits, I hope all of you know, are a no-no unless you've notified it as a meeting. Can't have a quorum out at a site. No ex parte contact, meaning individual commissioners shouldn't be talking to the applicant outside of a public meeting. That's a big no-no and can come back to bite you if you ever did get into a legal situation. Now in Armada, like I said, you are a small community and some of your administrative functions are handled by, a member of the Planning Commission. And I think that's okay as long as you keep it just that. You know what I mean? You're just your administrative contact with that. But there should be no specific meeting or getting additional information or a commissioner calling an applicant and asking specific questions outside of a public meeting. The reason for that is we also have the Open Meetings Act, which we're required to follow. And if it's ever perceived that information was provided outside of that meeting and you're using that as part of your basis for your decision, that would be not in conflict. That would be in conflict with the Open Meetings Act, meaning you were giving information that wasn't part of the public discussion. So just don't do it.
Okay, so can we ask questions?
Oh, yeah.
Okay, so I've been to seminars and they tell you this, that you're not supposed to have contact. But just a few moments ago, you said that a planning official should help the applicant go through the planning process and make sure everything's done. So you have to have contact in order to do that. So, and that is a give and take, and you do have to ask a lot of questions.
Mhm.
Okay, what are you doing here? What's this? You know, so that when they come to the planning commission, all the documentation is in place.
I think
So-
here it's different and it's a fine line you're gonna have to walk. Because in a lot of communities, you have an administrative person that's gonna do that is not part of the commission or the council. So here, where you're having Ben do some of that work, I think it's just important that you clearly document, what you're talking to this applicant about and provide that information to the commission. So any information that you do get, it has been documented and then is available to all the commission at the meeting, so that there cannot be ever said that you were given additional information outside, of the meeting. Again, it has to be a fine line, and you just kind of have to try to keep it as administrative as possible during that initial gathering step and not negotiate. You know what I mean? Not
Sure.
negotiation,
Yeah.
just kind of an information gathering. But that information also has to be given to this body.
Well, in the negotiation, that's where, that's not a fact finding. Negotiation is something totally different. So I can see that that's a step where you don't want to go, or a path you don't want to take. But in order to get the applicant to have everything, sometimes it takes quite a few reviews. And we've streamlined the process to come into planning by having the applicant have all the documentation presented at the first time. And I don't know, do you really need to say, okay, I talked to this guy and I made sure that the south boundaries and the east boundaries are designated? I mean, that's...
No, but if you were given information about the use, I don't know what I'm trying to think, the hours of operation, or who, something that might affect it in terms of what's going on with the particular application.
Well, that would be more like special approval land use, and special approval land use, because that's where you can dictate hours of operation, correct?
Yeah, but I'm just saying, if you were given any information outside of what would be considered, you giving the applicant your, advice on what the requirements are of the ordinance. You're required to have a north scale. You need to have, it need to be scaled at whatever. You have to, here's the parking section of the ordinance, those kind of things. If you're going beyond that and having a discussion with them where you're saying, well, the planning commission, would really like has really liked to have lately black aluminum fencing, along the front,
okay.
And, you should probably include that on your site plan, or, we really like Douglas firs, in the back, where you're starting to get into negotiations about the site and telling him those, or her, those things to put on the plan. We can't do that.
Okay, so that's over and above what we've done in the
If you're
past.
just saying, here's our zoning ordinance, look at section 17.02, I mean, that's hard. Again, in a perfect world, we would have an administrative person do that, so you wouldn't have to even worry about that, but here it's a little different, so we just have to make sure we walk that fine line and keep the boundaries clear.
So at some point in time, somebody else will be chair, and that's kind of one of the things that I've done and we have to watch out for, is just make sure that when you have these discussions, your discussion strictly what is going to be presented to the planning commission, what's lacking in the site plan, what's needed in the site plan, and that's pretty much it. Just make sure that the documentation is here, and they have an idea of what's going to be expected of them when they come to the meeting. But negotiation, I truly believe that's left to in the meeting or to council.
Right. And, the other thing is, again, the purpose of the Open Meetings Act is to make sure all deliberation and all information is public and done at a public meeting. So we don't want to have it ever perceived that some sort of action was taken outside of the meeting or deliberation was taken outside of the meeting. One thing many communities get in trouble for is email. I don't know how. I know Ben doesn't use email all that
I'll
often.
never get in
Ben's not
trouble
going to get in
for
trouble for email. But so I've had commissioners who the agenda gets emailed out to everybody, and then they're looking at the agenda, and then they start emailing each other about what's on the agenda. Did you see this sign is coming through? I don't like the colors, and start talking about it through email outside of a public meeting, and that's a violation of the Public Meeting Act. So that's another thing. Email has kind of become one of those things. I have some communities too that have gotten in trouble because they have laptops up at their, when they're sitting up here, and they will email each other in between the meeting, just commenting on the applicant. And it's during a public meeting, and the applicant is there. However, their discussion is not public. So you have to make sure the discussion's public and all of the information is done at a public meeting. Otherwise, you can get in trouble. We don't want that. Yeah, I mean, it's nice that it's nice when you do have that technology, but it also, like I said, can get you in trouble. Especially if some communities, I think maybe it was a couple years ago, it might have been Southfield, they were making derogatory comments about it, just talking amongst themselves on there. And it got FOIA, and the rest is history, and they got in trouble. So, again, technology is great, but sometimes it makes it too easy to get in trouble, too. Notices, like I said before, what's nice is we all go by the same rules now. But your notice for a public hearing of any sort need to include the request, the site location, the time of the meeting, the date of the meeting, and the location of the hearing. I've never seen a wrong notice done by here, but it's just kind of a nice refresher to know what you need to do. It should be simply worded. Use common addresses if there is an address for the site, because you have to remember who's reading this. This is the neighbors of the property that are reading the notice, and the general public when it's in the paper. So as non-legalese and as non-planning jargon as we can have in these, and still meet our statutory requirements is something that I strongly encourage, so that average citizen would understand what the notice is about. Because oftentimes I've seen notices where we just list the tax ID number. Nobody knows, where the tax ID number is or where that's located. I don't know my tax ID number until I look at my bill. So, again, just try to be as simple as possible. Notify adjacent communities if appropriate. The only time you're actually required to notify an adjacent community is with the master plan process. In terms of zoning approvals, you're only required to notify adjacent property owners, and if they're an adjacent community, you still have to notify them. But oftentimes, I find it a common courtesy and part of a greater planning effort and cooperation with your neighbors that if you had a rezoning that went from low-density single family to multiple family on the border with the township, might be nice to notify them that that's going to be happening and include them in the conversation. It might make it more of a pain in the butt and the process harder, but again, it's just part of sound planning and making sure that we work together, again, going back to what we're trying to protect, resources, the limited land that we have, and that we have a great, preserve our quality of life. So do that, keep an affidavit of the mailing, and generally required for every approval except site plan. Meaning all your ZBA stuff, your rezonings, your special uses, all require public hearings. And anything else in the ordinance that you've called out for a public hearing. In a meeting and during the deliberation, again, just trying to make sure we are consistent when we have all of our applications in front of us. And I guess one of the number one things in defensible decisions and making effective decisions is consistency. Doing the same thing for one applicant that you do for the next applicant and not treating people differently throughout that. Rules for speakers. I think one of the things that has worked well for some of my commissions, when we have, some of them do it for all their meetings, but when we know we're going to have a contentious meeting or issue on the agenda, putting on the back of the agenda kind of the rules for the people who are there, with identifying on there how much time they're going to have to talk, that they should, state their name and their address and kind of doing all that. It's nice for the chair to do that in the beginning, but it's also nice to have that written down for the general public to know. So that's just something that if you remember maybe for one of those next meetings. Hopefully we're going to have one for a while on something that's controversial. But generally, it should be a formal meeting. It's not intended to be workshop when we have a public hearing. Comments should be directed through the chair. If possible, we should always avoid the commission having a conversation with somebody in the audience. Again, it should be somebody up here speaking, giving their input at the meeting and going through the chair. I would encourage you to limit speaking time if necessary and maybe the number of times someone speaks. Often if you have a crowded house, ask them to identify a spokesperson so you don't get somebody up here all from the same subdivision saying the comment 10 different times. You don't get the association president or somebody else to speak on behalf of everybody. It just kind of makes for a more organized meeting that way. And so that you can have more effective comments.
So why can't the commissioners get into a discussion with people in the audience?
The reason you shouldn't be getting into a discussion with people in the audience is that, number one, that's not the purpose of the public hearing. The purpose of the public hearing is for them to come and give their comments to the commission as a whole, not to have a sidebar debate, with one commissioner. You want to make sure that you're in control of the meeting. You're not in control of the meeting as a chair if people are having individual conversations. And then it can go off on tangents, too, and lose focus of what you're here to talk about as well. Now, when we get to that, so you have the public hearing, they give your comments. That doesn't mean that the commission then doesn't have the opportunity to ask questions and respond to the comments that were issued. But there shouldn't be a debate between the commission and the public. They're here, I have some communities, I'm not saying it's the right thing to do, but in order for them to control their meetings and have this degree of formality, they do not even respond to the public. They take the comments, open and close, and they close the public hearing, and then they just discuss it amongst themselves. Because their purpose really is to just hear their comments on the issue that's presented. That's why.
Okay.
I know we are a little more informal, for lack of a better word here, but it can sometimes tend to get sticky because then here's another reason. If you're then having this conversation with somebody, a sidebar, you're giving them more of an opportunity to talk than somebody else, too. They may have just came up and presented their one topic, and followed the rules for speaking time and getting up and doing all of those things. So again, making sure everyone has the same. Mm-hmm. For you guys, generally speaking, it's recommended that your comments also go through the chair. That you say who can talk and when, and kind of control the meeting that way. Obviously, deliberation needs to be in the open. You are more than free to express your opinions, but your opinions and your decisions not necessarily your opinions, your decisions, almost regardless of what your opinion is sometimes, has to be based on the ordinance standards. So you might have a personal feeling about something or a project, but if our ordinance permits it, they came in and they comply with it, they've met all the criteria for site plan or even special use or whatever it is, it may hurt, but you have to use your ordinance standards to make that decision. And if it does meet those requirements, you have to vote for it. I know that sometimes people don't like to hear that either. Because if you don't, and you go into court, why did you say no? Because, of a personal opinion, that the judge isn't going to like that. It has to be based on the standards of the ordinance. The other thing I would always encourage too is, once you close the public hearing, keep it closed. It's done. Unless there's a need, you have so many people here and you need to postpone it and have a public hearing, continue it on another day or what have you. But once the public hearing is closed and you've given everybody the opportunity to talk, now it's this group's opportunity to deliberate on all that information. When you're making a motion for this body, you always have to have the maker and the second. You should be specifying what the request is. Motion to approve site plan application for, such and such address to permit a welding shop. And then, your action to approve and your conditions subject to them, whatever it might be, submitting, revised plans, planting more trees, paving the parking lot, striping parking spaces, whatever any conditions you might have. You should also include a statement for reasons related to this. Sometimes people do it after they've made their condition or even before, a motion to approve site plan, blah, 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 based on the findings that the application meets the requirements of the ordinance, will not be a nuisance to surrounding property owners. Whatever your conditions or your findings may be, it is really nice to include those in your motions. The reason why you're voting for or against something. Your motion should be clear to everyone, formed properly, obviously. Here, we kind of work together on motions sometimes when we create them, but it's nice to have them read back so you know what you're voting on. It's not necessarily a terrible thing to work together on what that motion is, but it should just end up being clear to everyone, properly formed, have your maker, your second, your request, your conditions, and your statement in there. And when your statement of reasons is really the big thing, the finding of fact. Why you're voting for it or why you're voting against it. And especially when you're voting to deny something, why are you denying it? And again, you want to make sure that you relate all of that back to the standards in the ordinance. If it didn't meet it, that's why you're denying it. If it does, that's why you're approving.
When we deny something, it's actually more, the regulations are more stringent that we have a paper trail than when we approve something, isn't it? Don't we have to provide written notice why we denied something? We do more than just doing it in the meeting.
I think our ordinance requires that we send letters of denial to if I remember correctly, the written notice. But there's not a regulation that's more stringent for approval or denial, but the consequences of not having something for denial is probably what you mean. If you don't state clearly in there why you're denying something, and your reasons for it, and have that documentation of the minutes and the comments heard and all of that stuff, if you were to get challenged on it, there could be a question of, well, we met these requirements. Then it's them saying, we did all of this, they just denied us. They didn't say why they denied us, they just denied us. So we want to make sure we identify why they denied us and then notify the applicant as well. In terms of implementation, in the zoning process, once you guys have made your decision, make sure you have those signed site plans, which you guys do that really good at the meeting, but have a copy of it here. That is your legal record of what can happen on that piece of property and what occurred at this meeting. So it's important to keep that, as well as the minutes and the denial letters. Make sure your files include, obviously, the minutes, any staff notes, or Ben notes that you may have had with the applicant in terms of information that was obtained, all the information that was submitted with the application, the site plan, and any other correspondence that you may have received. And you really need to keep that all together. Again, if you were to ever get challenged, you want to have your case there and why you made the decision you did.
When we do conditions of an approval, should the conditions be in the minutes besides being on the app? What we do, we put them on the application. Becky, you usually put them in the minutes too, don't you?
Yeah.
So is that required also?
To be on
So that when we have the meeting, and if there's conditions of approval, we write it right on the application or on the second piece of paper, whichever is advantageous, signed by the chair and the applicant, and everybody gets copies. But we also do it in the minutes of that meeting to be approved at the next meeting.
They should be in the minutes because it's part of the motion.
Okay.
It was part of the action that you took. You could even put on a plan, and I've done in some communities, approved per condition specified and date the meeting. Problem with that is it's nice to have them all written out right there on the plan, so you don't have to go dig up the minutes too separately. But it can be done either way, written on the plan, or it has to be in the minutes, but it can be written on the plan too. But the minutes is part of your motion. And if it's not part of your motion, it was just part of the discussion, it's not part of the action. It's another important thing. Like a lot of times, commissions will talk about things and they say, we want more trees, or we want, this lawn area to be greater, or what have you. And you all had part of this conversation. The applicant agreed to do it. but you made the motion and you didn't include it in the motion, then it wasn't part of the action. So you have to make sure you include it in the motion, because the motion is actually your action on the site plan. So that's where everything has to get specified. Just a little quiz that we have on there, and it's not really even a quiz, it's kind of obvious, but the best time to update the zoning ordinance is, you know, whenever you get sued and lose, obviously, then there's something that's in your ordinance that we are not able to defend. So we want to make sure that we address that. I'm working on a case in, again, Garden City, where we've lost 2 cases now, unfortunately. I disagree with the judge on both of them, but regardless, she made her decision, and now we have to allow chickens in the community. So now we have to amend the ordinance to allow chickens. We also, and you might have this issue here too. Yeah, and one I was kind of iffy on because it was a platted lot. They had several acres, and I was like, all right. And then the next one, it was in a subdivision. To me, it's different. So I think the city's still deciding kind of whether or not we're going to challenge it, but we'll see. Whenever your attorney or I tell you to, obviously, usually I'm not going to recommend an ordinance amendment. Probably your attorney isn't either, unless something has changed in legislation or there's new issues or, you know, something to address. Topics that have come out recently that have required amendments to ordinances, you know, may have dealt with medical marijuana. One that a lot of communities are dealing with are fireworks sales, and how, you know, how you regulate those. But another hot topic here. Wireless communication facilities. I think I looked at your ordinance and we were okay, but there were changes in legislation that some communities did have to change their ordinance in regards to those things. In regards to wireless communication facilities, the legislature, for the first time that I've ever seen, has limited how much a community can take on application fees, has said that you have to allow co-location without coming before the planning commission. And said you can only require special use on a brand new facility. So they've kind of gotten very specific in what you're allowed to do. And our ordinance already did that. So we were okay, but some communities weren't. So really that's where you're going to get it from us. Whenever something comes up that you hadn't thought of, like lighting, you'll be having some lighting presentation next month. And there may be some things you want to change in your ordinance there after your master plan is completed. And then a minimum once a year. You know, that used to be the rule of thumb, because as you know, you often go through an ordinance and you kind of find little things that don't make sense after you've tried to implement them. It's kind of, I don't know, it's kind of working out the kinks. Like, you think it's a good idea when you write it, and then you try to apply it sometimes and it doesn't make sense to every situation. So I like to keep a list in the front of my ordinance, and those are the kind of things I clean up. I recommend cleaning up with planning commissions. Once a year might be a little much these days. We don't do all that much, but it's just nice to keep kind of that running list. So the correct answer is all of the above. If it wasn't obvious enough. In terms of the ordinance, amending the ordinance, we have 2 types of ordinance amendments: zoning text amendments and then map amendments. Text amendments are the ones where we create new districts, and we do those things obviously to implement the plan, clarify language, change procedures. Just a reminder that when we do that, to make sure you look at the whole ordinance, not just the one little section that we're amending, because it could have implications on other sections. Because some sections refer to other sections in our zoning ordinance, so you want to make sure you don't just look at the bubble of what you're focusing on with your amendment. In terms of map amendments, rezonings, we have 2 types. We have just a rezoning, a regular everyday rezoning, and now we're also allowed to do conditional rezonings, which I'll talk about in a second. But the rezonings, when you're looking at that, the factors that you consider is the existing zoning reasonable. So when they're requesting a rezoning, is what's there reasonable? Is it consistent with the master plan? Can the location that they're asking for this rezoning for accommodate the allowed uses? Not just the use they might want to do on it, but all the uses that are also permitted in the district. Because once you rezone it, it can allow anything that's permitted in that district. So you want to make sure that all the uses can be accommodated and that they're compatible with the surrounding area. in terms of conditional rezonings, we haven't done a conditional rezoning here, have we?
No.
This is a relatively new concept. It used to be called, I'm trying to think of the name they used to call it. Contract zoning is another term you may have heard for it. But our zoning enabling act was amended, I think 3 or 4 years ago, to allow conditional rezonings. And what that is that an applicant can come in and request to you a rezoning and attach to that rezoning certain conditions or an offers. So I'm requesting to rezone from single family to multiple family on a site that might be planned for single family, but I'm going to say to you as part of that rezoning, I want to be rezoned multiple family, but I'm not going to have a density greater than the density that's permitted in single family. They just want to do it to allow that type of unit to be constructed on the property or what have you. I've had ones where they have asked for, I had a rezoning in one of the communities I work for, the sale of beer and wine, any kind of alcoholic beverage, is only permitted in their most intense commercial district. So that's a C3. This was a C2 site that a 7-Eleven wanted to go into, but they wanted their beer and wine license. So they asked for a conditional rezoning to C3 to only allow C2, uses already allowed in C2, and the sale of beer and wine. So all the other uses that weren't appropriate for C3 wouldn't have been allowed on this site, just that one use. So it's a tool that you have where you may have had a rezoning before requested of you and you thought, this could kind of work on this site, but it wasn't consistent with your master plan, or all the uses weren't compatible with the surrounding site, or something wasn't right about it for you to be able to recommend approval. This is a way for you to, for lack of a better word, kind of be like a PD, but it's not. It deals with just use. When doing this, though, important things to remember about the act and what's required are that the Planning Commission cannot condition the rezoning. The applicant has to offer these conditions to you. So the applicant has to come to you with the offer of conditions.
Oh, this isn't a negotiation process?
That's the difference between this really like a plan development.
So, so if does it have to be, does it have to abut another piece of property that maybe has that, like your example, the C3 and C2, does it have to be contingent of those? That's not the right word, was it?
Does it have to be adjacent to another
Okay.
C3?
Yeah.
No.
So you can spot zone kind of in this?
Again, here, it's not really a spot zone if it's generally consistent with your master plan. So in my case, in that example that I gave, by allowing them to sell beer and wine was still consistent with the master plan because we had that area planned for commercial anyway. It wasn't changing our vision for what was to occur on this particular location. C3 in this community allowed some more intensive automotive related uses on the site, drive-through car washes, gas stations, that kind of thing that would have been appropriate on this particular site, and they agreed to not allow those uses. So what happens is it gets rezoned to that C3, these conditions get attached to it, and in this community they require those conditions to get recorded with registered deeds.
So that's permanent to that piece of property then?
Yep, and
So
until you
this would be-
rezone it.
So it'd be seller to seller?
Oh, yeah.
Okay.
Yep, it's not just for that particular use.
So it's not a special approval land use type
Nope,
thing?
nope, it's an actual zoning, it becomes the zoning of the property. Yep, and the subsequent owners have to abide by that zoning. Your map has to show it as a conditional rezoning. However you choose to do it with an asterisk, which, however it gets identified as a conditional rezoning. But those conditions have to be documented, because they are transferable until the site gets rezoned again to whatever.
But the applicant has to request it, the planning commission can't suggest it.
No.
What if you suggest it?
Again, I guess
Somebody comes
what
in and
nobody
wants to
knows
do
doesn't
it.
hurt you, but they cannot, if they, I guess if they went to a judge and said they coerced me into doing this and I didn't really want to do this, this was the only way I could get approved, was they said that I had to offer these conditions, but I don't want to offer these conditions. You just have to make sure you're not like that. What you could say is, did you know we have this thing called conditional zoning amendments? You might want to go look at that. But you cannot say, we'll approve this if you offer these conditions and go through what those conditions are.
Because
No,
clearly
that's what I was
some-
gonna say, because it's a lot of give and take. We ask the applicant questions,
Mhm.
and a lot of times that makes the way that it works out best, because you almost want it to happen. We try and figure out sometimes the best way to let that happen without going against the ordinance or
Mhm.
whatnot.
And sometimes, and that can be a good tool for that, this. Oftentimes it's where I can get involved, because I can go, I am not the council, or the planning commission or the council. So I can go to an applicant and talk to them and coerce them, for lack of a better word. And to, say, hey, you might want to offer this. Here's another way to approach this development. That's my job, to give options to people.
Okay, we do have an avenue then.
You do have an avenue.
Okay.
It just cannot be, and I am really not sure why the legislation was written this way. Somebody probably wanted it, for whatever reason. I don't know why a lot of legislation is written the way that it is, but you just can't, they have to be offered to you. You cannot approve it subject to, like a site plan. It has to be offered.
It kind of sounds like, almost, we've gone through special approval land use, which is a pain, but it almost sounds like that again, and if you guys come up against that, it's almost best that the planner be sitting here on board, just like sometimes with the special approval, to help
Navigate.
guide things, so we don't make a mistake. I'm not saying it's gonna happen, but it
Yeah.
kind of looks like you want to have as many eyes looking at it as possible.
Yeah, and the other thing is, when you have these conditional rezonings, you're still looking at it based on the same standard as a regular zoning, so is whatever they're asking for with the conditions compatible with the surrounding area, consistent with your vision for the master plan, all those good things. Required, make sure the public is kept informed in the process, you have to have your public hearing and so forth. And that's why I say get advice from your attorney, plans, etc. It's a great tool, but just because of that kind of sticky requirement, you kind of might need help to navigate through that process. At least the first time.
What would be the difference between a special approval land use and this?
A special approval land use is, the zoning's already there. It's just that use in the district is a special approval. It's a discretionary use in the district. You have in your districts right now, you have your permitted uses, which are permitted by right, which when you create those, you're saying these uses will be appropriate on all sites zoned R1. And then you have your list of special land uses. And these uses might be appropriate on some sites zoned R1, but not all sites zoned R1. Like a church or a daycare or whatever, some of these uses. And so when you have it as a special land use, statute gives you more discretion in making sure that use is appropriate for the site. That's why you have those discretionary standards to evaluate it against. Not just, does it meet the setbacks, the height, the landscaping, the parking, those general requirements, but with a special land use, it gives you some discretion. And that's also why there's a public hearing, because you're having discretion over why you may or may not approve that use.
So does this go beyond the special approval land use?
No, this is rezoning. It's just a rezoning. So it
Okay.
gives you a tool, before we just had rezonings and you
So
said, is it
basically, it is
consistent with the
beyond
master?
special approval, because then you're actually rezoning it for that, okay.
So before we had this option, when we looked at rezonings, we said, is it consistent with the master plan, compatible with the surrounding area, and so forth. And if it wasn't consistent with the master plan, or what have you, you said no, you didn't, or you should have denied the rezoning. Now, with a conditional rezoning, it may not be on the surface that plain and simple, but with the conditions attached to it that they're offering, what might be off-site improvements related to rezoning. Maybe it wasn't appropriate to have this area zoned from C2 to C3 because of the traffic or the uses that might be permitted. So one of the conditions that they're proposing to do is widening the road or something like that. Or putting in additional landscaping or something like that, which would make that district now appropriate for that site, if that makes sense.
Does the special land use just go to the applicant, or is that be passed on to when they sell their property to the next person?
It goes with the use.
It goes with
So
the
if the
use.
use goes away though, then they can't just automatically
Okay,
come
so
back.
if in this case, the 7-Eleven is selling beer and wine or
Mhm.
something, then if they sold to Joe Schmo Party Deluxe or whatever,
Mhm.
he can still sell beer and
Mhm.
wine. Now, on the special land use, would that still be the same case?
Yes, because it goes with the
It's the same
use.
use.
It's the use, as long
Okay.
as the use doesn't change.
So that wouldn't change. So that's not any different than this, in that regard.
In that regard, no. But the difference is, here's where the difference is a little bit. With a conditional rezoning, even if my use went away, that zoning is gonna stay there. Just like even if you had a business in downtown and that business went away, their zoning still stays there and and a new use that's permitted in that district can come.
Can that be reversed?
You could, one of the conditions could be that if this use were to go away or cease, for a certain amount of time, conditions could be anything really, that it would revert back to whatever it was before. I've done that too. I've also done that where we've given them a certain amount of time to actually construct what they're proposing and as part of the conditions, and if they don't, then it reverts back too. So you can have reverter clauses in there. And I would suggest that you do. But the difference with that, with the special land use is, the special land use goes away and that building is vacant for a certain amount of time. And then they have to come back, that it's like a new use. You have
I thought special approval land use, if there was a new person going in there
to,
Correct.
and they wanted to do the same thing, it'd just be start all over again.
do they meet the same criteria and so forth in the ordinance? And, it has to meet everything that's new in the ordinance, just like a new use going in there.
Correct.
So if you had a new use going into a vacant site and it doesn't meet your landscaping or whatever your current standards are, your ordinance, it should be brought up to compliance.
Well, I think Steve's thing is, so we have we approved a special approval land use for XYZ company to make widgets. So now that XYZ company the owner wants to retire and sell out.
Mhm.
So now a new owner comes in and he's going to name it ABC.
That's
company.
fine.
But from what we know, that a special approval land use is not transferable.
Who's told you that?
That was,
That's been
I mean,
as
that
long
seemed like
as.
the impression I had from
Sure.
way back.
Every use that came in can always went through another.
So it
Yeah.
it goes with the use, it doesn't go with the person.
Well, not necessarily saying that that was right, but that he has been what.
I've
So,
never advised that or been told that, and that's not what statute says. So I don't know. I'm gonna have to look at your ordinance again, but no, it goes with the use. You're approving the use for that site. Ownership doesn't matter. Kind of like a nonconformity. If you have a non-conforming use in a building and the use changes to and the ownership changes, it still can stay and operate and be there. It doesn't have to go away because there's a new owner. It's the use.
yeah, we've always done that. That way it was not transferable.
Have you ever been challenged on it?
No, no.
Well, I mean, until you get caught, but no. I mean, I've never been advised that or had any community do that.
So, okay, you're saying that a special approval is transferable. So this is gonna be interesting for the Ray Township thing.
Yeah.
So now they've created something, and I'm getting off the track here, but if it's vacant for it exhausts the
ceased?
grandfather type clause, 1 year it's vacant, then the special approval lapses.
Yeah, if there was an intent for the use to go away, it has to also be, you know, kind of like a non-conforming use. There has to be intent to leave and that, you know what I mean? It's not like a seasonal use or something like that where they leave,
Mhm.
you know, for so many months. If there was an intent to leave or abandonment of that use, it starts over from the beginning, you know what I mean? It's a vacant building, new use. They have to comply with whatever standards you have in place now, you know.
We'll say the company went out
District.
of business, and now the business sat, say it went into foreclosure or was for
Mhm.
sale, and it didn't sell, and a year and a half later it sold, and the new guy wants to do the same thing, he's got to totally reapply.
Yeah.
Does that have
Okay.
to, does that have to be in writing? Do you have to have it in an ordinance someplace saying, if in 1 year, if you're vacant for a year, if you're
I'm gonna look at
2
your, and
years?
unfortunately, I'll look at your ordinance to see if you specify. Some do, like, we actually, in one community I work in, Lincoln Park, we extended special use to go 18 months because we've had this issue. And we said that if a use, that special use can only be, after the expiration of 18 months, then they'd have to go through. So we allowed that special use to carry through for 18 months after it was considered vacant. And we did that there because we've been having a lot of issues with foreclosures and so forth. And we've been trying to get a lot of these buildings reoccupied, and it's been putting a burden on some of them to get it reoccupied into the same use that they historically were. And they're not gonna be anything else. So we extended that to give us more time to deal with that foreclosure process, auction, you know, all that kind of stuff. So in Lincoln Park, we do 18 months for that. So after 18 months though, that special use goes away.
So
Yeah.
you just became flexible because of the times.
Right.
Okay,
And a
so-
lot of communities are doing that kind of thing.
And understood, and I would say that's prudent.
Mhm.
So, but where do we stand with, and, because I know we've approved special approval land uses and told the applicant that that was not transferable.
Was it one of the conditions of approval?
I believe that sometimes it has been.
If it's a condition of approval, that's different though, because you can condition it upon that.
We can.
You know, because that's
Oh, then
condition.
foreclosure
You're allowed to
agreement.
do conditions. You know, you can
Okay.
condition special uses just like you can condition a site plan or a variance. So that's something different though. So you have to look and see how it was approved. And you know, if you've done it sometimes or not others.
I know we always assumed that, but I think it has been
Yeah.
done a couple of times.
Yeah. I always thought it went with the applicant, you know, I
Yeah.
didn't realize that they can just transfer on and on for eternity.
One of my communities,
not
and we've recently
transferring.
amended
Well, it's
this
not
ordinance.
transferring,
It
but
stays.
Yeah.
That's-
Yeah.
you
I think
say-
that's
it goes
decades
from one
of it.
person to
I
another
think
to
of-
another.
but how many of them are really, you can think of are the exact same, you know, like I keep
And
thinking.
it has to
of,
be, yeah.
Ezos, because that's the industrial, but we never had the same, there were uses, let's say, of it, but not the same ones. And
But if
then
it,
come back.
now if it's
Trying to-
manufacturing to manufacturing, they don't have to manufacture the same exact thing, right?
No,
Well,
but
but
the
the use could
processes
change,
and things.
and it could be an
exactly.
intensity change of the use regardless of what they're changing. There could be intensity in the delivery trucks that come, you know, the number of employees that are employed there, you know, so just because they're manufacturing this type of widget and they go to this type of widget, there could be, you know, consequences on that, you know, it's not necessarily the same use. There could be consequences that impact why or why not a special use might be appropriate to that site. But it doesn't go with the owner, you know, it goes with the use that's occurring on the property.
Okay, so now you just brought up something, so you've passed a special approval land use, and as, say, Joe's business increases, and 10 years down the road, he's doubled the amount of traffic, he's doubled the amount of employees, he's doubled everything that he's doing, and he was never approved for that. So what happens at that point?
You know, generally speaking, not knowing the specifics, I would say he's not in compliance with his approved use.
So then what?
Then you cite him, and you get him to come back to, you know, reapply for the use that they're doing in it. Apply for a special use for what they're doing, and you either approve it or you don't. You know what I mean? You approve it or you don't based on our standards and our ordinance and the whole process.
So,
But you can,
wow,
they,
that's a sticky wicket.
I know, that's,
none of this stuff is fun. I mean,
Yeah.
it's not always easy or fun, but that's,
I liked where we were before you came.
I'm sorry. If I hear that on one, that's not the first time.
one more
Just
quick
had that.
question.
Yeah, we
One more
did.
quick-
Right, that was right around the.
When,
Yeah.
when
Down the
would
street now.
conditional zoning when would you choose conditional zoning over special land use?
Well, like I said, a special land use is, if the site is zoned whatever right now, R1, a special land use, you're only gonna get, those uses are already listed in your district as a special land
Right,
use.
In our zoning ordinance, there's that table of the uses, it'll say the P and the S.
Right,
So that's an S in that zoning district.
right,
So
right.
the difference, you want to rezone something that isn't in there, you want to put in there.
Right.
You want to be industrial now in the C1, for example.
Right. Yeah, I get that. I'm just thinking in terms of to like maintain maybe some control. Like if somebody wanted to do a conditional zoning, could you maybe advise that, you know, they do a special land use instead?
Well, they could only do a special land use if the district that they're currently zoned right now, the use they want permits that special land use. It might not. You know, like my example that I had, they were zoned commercial. It just didn't allow the sale of beer and wine in that commercial
Right,
district.
so
that
they
were
couldn't
in.
get a special land use
No.
for that. Okay.
So say adding someone in the C2 to C1, the township is really where you can see a ton of that in. Like,
Yeah.
It's all the result from agriculture to anything,
Right.
right, comes up. What's desirable in this area may not be, you know, they may want industrial, let's say over by Powell versus, oh no, we're gonna do commercial instead. I'll give you some conditions to help that.
Right.
You know, and in some cases, in some ag communities that I've worked in, like the township, you may have agricultural land that wants to do a, sell their produce, not necessarily like put a store out front that sells their produce or what have you that they make, or milk or whatever it is. And in some communities in ag, we don't permit that. You know, we might permit a roadside stand, but not a store with a parking lot and so forth. So in that community, it might be appropriate to do a commercial zoning on a portion of that, with conditions that limited to the use could only sell products that were, you know, grown on the facility, you know, on the land or what have you. And if they didn't do that, then it would revert back to ag use or something like that. So that would be one of the conditional rezoning things that you might think about.
So can you do a conditional zoning in lieu of a special approval, if special approval is an option?
I don't know how you would.
Doesn't say, because you're saying it was already a permitted use, but only under special approval versus a use that's not even listed at all.
Correct, so,
So to make it go from a special to a permitted, maybe you're thinking?
correct.
I don't know, I guess. I can't think of a situation where you might do that. Because if it's permitted already in the district that it is as a special land use.
But again, it's permitted under special approval land use, but it's not permitted and it's not rezoned. So now, somebody might say, my property is more marketable if I have the proper zoning and the zoning is with the building. So now, so with the special approval land use, you do have the thing that, I'm 70 years old and I have a store and it's, and we're, my welding shop and, I'm industrial, but say I'm not in industrial, I'm a special approval land use. Okay, so now I go to retire and I'm starting the ball rolling, but I have a heart attack and pass away. So now it's 2 years down the road before all the dust settles and the building is sold. So under special approval land use, that whole process has to start over again. But if this was in the conditional zoning, that process would never have to start over again because I've been zoned properly.
Industrial. Now, the conditional zoning though would be, you would be zoned properly subject to condition, like that. You don't just say it's conditional zoning to.
But you don't have to, you don't have to start the
district.
process over again. So I think for a resale condition, so I would say, as for the planning commission, it really doesn't matter. For the applicant, I think it does matter.
Sometimes. I can say though that sometimes when people are doing it speculatively, you know, oftentimes I don't have an applicant willing to come in and want a rezoning from a C1 to a C2 with conditions because, you know, they don't have a use or something that's going to go on that site and they don't want to be bound by conditions. So oftentimes it's associated with an actual, you know, project and a plan. One that I've had also, we attached a site plan to it. you know, that you are rezoned this, subject to you doing these things, you know, identified on this plan, which were above and beyond what would normally be required under traditional zoning. So there's kind of no limits to what the conditions can be per se. And, you know, but I've never had one do it speculatively, you know, a condition. But maybe in a case like that, where it's a non-conforming use, maybe. I just haven't
Mhm.
done it.
Well, if it's fairly new, then.
Yeah, I want to say it's 4 years. You know, if 4, maybe 5, I could double check. I'm really terrible with remembering when
On
things.
this, the conditional?
Yeah, when things.
Oh, that's been 8 or so. 'Cause I
Has
think we did our training with council in
See, I'm
04
terrible.
or 5.
But I've only worked out, I could tell you in that whole time that
Right,
we've
'cause
been
that's
allowed
we
to
did
do conditional
PUDs and all
rezonings
that, so we had the
Maybe
whole council
5.
here too.
in all my communities, you know.
Wow.
So it's not, it's a great tool for specific sites, but it's not like a one size fits all.
What's the cost on something like that? I mean, we know approximately how much to charge people for a special approval land use because we know how much your time, you know, all those kinds of things. Is there a general idea on how much to charge somebody?
Here, I would probably charge more. I guess, you know, and I could, you may want to get your attorney involved in one too, in one developing the contract and the restrictions on the property so that it gets recorded in legalese and it gets done properly. So I would definitely collect more of an escrow up front on an application like this. For sure.
Would this be a public hearing also?
Yeah, you process it the same way as you do a rezoning. Everything's the same as a typical traditional rezoning.
It almost sounds like you would charge as much as a special approval land use to cover the
Yeah.
planner and the attorney and.
That's probably more in line with what it would end up costing.
But I think it might actually cost the applicant a little more because now they've got to do the filings that you don't really have to do with special.
And I would also point out though that this is just the rezoning. So if they rezone it to a C2 or what have you, and the use they still want to do is a special use in whatever district they're asking for, we can't change that. They still have to come through and do the special use process. So let's say they wanted to rezone it to industrial, but
So
the
this
use
is-
that they want in industrial is a special use, they still have to get special use approval. This is just zoning.
So this is the zoning procedure, then they have to still come in for the approval?
Yep, this is just zoning.
Okay, so it's way beyond special approval.
It could be both.
Well, the
You know what I
special
mean?
approval you can approve at the same time. This doesn't sound like you're gonna have one motion to approve the rezoning and another motion to approve the applicant.
But the special use you can only do if that use is permitted in that, as a special use in that district right now.
Understood, yes.
So if you're rezoning to something else to get that use to be permitted on that site, it would go through permitted or special, whatever it is in that. You can't change
Yeah,
the use and how the use is permitted as a condition
in the special approval.
in the conditional rezoning. The only conditions can be related to like physical improvements on the site, limiting of uses, but you cannot allow a use in a district that's not otherwise allowed, or, you know, change what's permitted or special use in the district as a condition. So you can't say, I'm gonna,
confused.
I'd rather
I
do
thought
it-
that's what the whole reason of doing it.
I'd rather do a special approval land use.
I think so
But
too.
it might not be allowed.
but what I'm
in
saying is your
conditional.
use, if you were zoned commercial, your use
Well,
isn't
let's go back to
allowed.
the guy that wants to sell beer and wine, but he can't sell beer and wine because of the, because of the criteria of that zoning.
Yeah, so that's a good
But so
idea.
he's not allowed to do it, but if you rezone it to the new
C3,
zoning,
yeah.
the new zoning will allow it. And then it's approved.
Yes.
Then you do
Okay,
it, but
under the new zoning.
if in that community,
Well,
the new district
say
only
approve.
allowed the sale of beer and wine as a special use in that
Exactly.
C3, he still would have to go get that special use
Oh, I
approval.
got you.
You have to do
Okay,
both.
You
okay.
have to do both.
Okay,
Yeah.
so now you're really stretching it if you're rezoning it to something, that something that you're rezoning into
Was already
is,
a special.
the usage is a special approval in that one, okay?
Right.
That's really out there on a limb.
Yeah, but
But-
remember until we redid our list though, how many S's were in a lot,
Yeah,
those
yeah.
one of the columns, or those rows there.
So you, but
Quite a
that
few.
condition
Yeah,
can't
it
change
was.
that, if that makes sense. You know, I can't rezone, in that case, I couldn't rezone to C3 to allow the beer and wine by right. I can't change that as a condition. It's what the district allows. So.
Wow.
It's a tool that's out there
Yep.
for us.
That was a can of worms.
Yeah, sorry.
September '04.
And we probably won't get one. Well, who knows?
Ours in July '05. we did a trial.
Yeah, like I said, it's not okay to relax the zoning requirements or permit uses that are not approved or accept cash donations or donations to the city, you know, in exchange for allowing this, you know, that can't be one of the conditions of approval. It has to be something related to the use or the actual zoning district itself.
So you can accept checks or credit cards.
Well, yeah, there you go. Right.
That's important. There you are.
A spot zone is something that we often hear about. And usually when you look on a map, it's something that's, you know, smaller, you know, a district that's smaller in size than whatever surrounds it. It's usually not consistent with the uses allowed in the district. And it often confers a benefit to a property owner that is generally not available to other properties in that area. So that's something you want to completely avoid. But when a spot zone is appropriate is when it's consistent with your master plan. So you might have planned for this area to change and evolve into something else than it currently is zoned or used for. So if somebody is coming in and asking for a rezoning of that piece of property that is consistent with your master plan, your goals, your visions, and so forth, it is not considered a spot zone in that regard. Yes, it's gonna look like it, you know, just if you looked at the map, but if somebody opened up your future land use map next to it, they would see that it's not a spot zone. You're looking for that area to change.
I thought spot zoning was never appropriate.
When it's truly a spot zone, when it's what I just described in those three previous goals, when it's smaller in size, it's not consistent with the uses allowed around it, or planned to be around it, it confers a benefit to those property owners than others wouldn't receive, then it's not appropriate. But if we have an area that's currently, it might be commercial, and we've planned for it to evolve into industrial, and someone comes into that commercial district and applies for a rezoning to industrial, that is not a spot zone. Even though it still might be surrounded today by commercial, it's consistent with our master plan. It's what we've planned for that area to happen and to evolve. When that does happen, that might be at a point when the village thinks, well, maybe we should initiate rezonings on other properties too. You know, if you start to see the change.
So that's if it's in the master plan that you want
Yes.
to grow to that there.
Yeah, if you're,
Spot zone is approved.
so it's not really considered a spot. I say that
Okay,
because
let's say
but
it's-
people always, when they see it on a map or see it like that, that's the word spot zone.
So
comes
you
out.
really want to grow so it's, it abuts your property, but you're saying that you could skip a couple of properties to get that zoning done, so you're kind of
Yeah,
updating.
and you know, it's not uncommon to plan for an area to change or evolve over time into something else. So if that zoning request, it might look like a spot zone on a map, if you were to just look at the zoning map, but it's really not. It's really implementing your future land use map.
If I can go back, I know we spent a whole lot of time on this conditional rezoning, but they, okay, it's not okay, so I answered my own question. Okay.
Okay.
Oh, everything's okay.
The other tool that sometimes people get conditional rezonings confused with is planned developments.
Putts, yeah.
Mhm.
PUD, yeah. And this is a tool that we have, and what it's different about this and the rezoning is that this does allow us to negotiate, use the carrot and the stick approach. And you can do the negotiations and it's, you know, that's part of the process. It should actually result in a better development than you would achieve under conventional zoning. You know, the purpose of negotiation shouldn't be for you to give away your standards just because. You know, you should be getting something in return. Similar to a conditional rezoning, require a contract and agreement clearly specifying what it is that we negotiated and deviated from, and what the terms and conditions are, you know, what uses will be permitted in this plan development. And then it allows you to do things like permit a mixture of uses that would otherwise not be permitted on the site, or modify our, you know, area, height, and bulk requirements of the ordinance to give us some flexibility without going to the ZBA for variances. So you have the ability to look at a piece of property and evaluate it and see what works, and then if it results in a better development for the village, be able to approve it as a planned development. And so that's different than the conditional rezoning. Have you ever done a PD here?
No.
No.
There's no PUDs here.
Sorry, sorry.
What, now, are PUDs usually started by the communities or by somebody outside the community that wants to
Phase
develop
three was
a large area? Or
It's usually the applicant that will propose the PUD to you.
No, phase 3 of our main amendment.
Oftentimes it comes
The
about
closest we've had to
with an applicant who's coming to you for a rezoning and you've denied the rezoning or what have you, but this is a tool because the rezoning wasn't able to meet the criteria or what have you. So they may come back to you with a plan development, and then you're able to look at it more on the site specific, negotiate the individual aspects of the development with that developer.
Yeah,
But oftentimes,
we started.
it's never, I'm trying to think when you would ever have the village be the person to initiate it. You might be the one to suggest it, but it's obviously going to come from the landowner.
I'm thinking of like if you were like out in Wyoming and you had all this land and you wanted to develop a part of it,
Mhm.
maybe a community would develop it as a PUD, which is just mixed use because it can be single family and duplexes and retail, or it could be retail and single family and industrial. There's so many different things you could do.
In that case, and I didn't go into this in here because we could talk about stuff like this all day, or I could. There is a tool that's called an overlay district, where you can have your underlying zone. Have you ever heard the term overlay zoning? You would have your underlying zoning district, and then you can create what's called an overlay district, which are regulations that go on top of that district that would allow some flexibility. And oftentimes what some communities will do like that, in a downtown or something, you may have it zoned CBD, but on your main street, you might have an overlay, and in that overlay just along Main Street, even though CBD goes around different areas, you have different regulations that would allow different mixtures of uses, different building types, different so forth, but your underlying zoning is still the same. You know what I mean? But you have this overlay. Some communities do it as an incentive and an option because they give you some things with it, like if you comply with these things in the overlay district, you might reduce your parking requirement, or if you build your building to a certain design standard, they might give you increased height or what have you. There's certain tools like that. But that's a tool that a community would probably use more than a PUD. Would be like an overlay. But oftentimes these days, I think people just create their CBD to implement the standards that they have. But some like overlays. It gets complicated an overlay gets complicated for an applicant. That's what I want.
Sounds like it's complicated for everybody.
Well, yeah, it is. I don't know. Some people ask me, what do you do for a living? And then I'm like, really? Do I have to try to describe when I do all these things? Do you know what zoning is? That's usually where I start. So, special land uses, we did talk about these already. I'll go through them quickly, but it's uses that would otherwise are compatible with this district, but only in certain locations. And then again, you have specific standards. Usually with the special land use, you have your general standards, such as in our ordinance, we have our general standards for special uses that they have to comply with, like the project shall be designed, constructed, operated, maintained to be harmonious, with the appearance, intent, of the character of the general vicinity. That's like a general discretionary standard that we have. You also then, depending on the use that comes in, you may have a specific standard for that use. And we have some of those in our ordinance as well. And that may require that it be located on a primary road, or that it has certain screening adjacent to residential, or I'm trying to think what other standards we might have, for, there might be stuff related to noise or what have you, depending on the particular use. But in our ordinance, we have that, and in that chart of permitted uses, it says, it refers to whatever the specific standards might be next to it, so it has to comply with both. The other, like I said earlier, if all standards are met, you must approve the application. our chance to,
So what's the ramifications if you don't approve? It has nothing to do with Armada, but a friend of mine did this process many years ago, and it almost bankrupted him. He did everything the planning commission asked, and they still denied him.
well, I would say that if that is truly what happened, he would have a case in court to take the community to court and seek, I mean, I'm not a fan of doing this, but seek damages, from the community, or get his use approved or his site plan. Often what happens in that case is if you go and challenge the community in court, it enters into some sort of, agreement between the two. At that point, some sort of consent agreement, to allow him to develop. If he had a case, I don't
Well,
know.
he had a case, he just didn't have any money to pay a lawyer anymore.
And that's unfortunate, yeah. But that would be his consequence. Not his consequence, his avenue.
So that community was definitely breaking law when they refused him.
If he complied with the ordinance and it wasn't approved, yes. Mhm.
Well,
Now, he also has the option to appeal to the zoning board of appeals.
I didn't know any of that back then.
Mhm. You can appeal a decision to the zoning
But you
board.
said earlier that they have to specifically state what they are
Right.
denying it for.
Mhm.
What if they don't specifically state it? You get some.
It
planning
makes
commission
you
members
more susceptible to being challenged and not being able to defend your, you might be right, but if you didn't cite it and follow the correct procedures and notifications and all of that stuff, then your decision could be invalidated. You're more susceptible to being challenged and losing in court. One of the first things they'll always go after are procedural stuff. Did they notice the public hearing correctly? Did they take the minutes? Was everybody's comments in there? Kind of the easy stuff, but an attorney will always go and look at that stuff too, Was their master plan that they used as the basis reviewed every 5 years? Is it still valid in the community? So that's why you kind of want to make sure you keep doing your homework and have that stuff taken care of, so that if you do get challenged, they can't challenge you on that stuff.
Well, you just mentioned minutes, but minutes are just a synopsis of the meeting, and they're not a verbatim of anything. So comments that were made wouldn't necessarily be in the minutes. You would just have the gist of that conversation and not specifics of that conversation.
But it should record everyone who spoke during a public hearing. Do you record who spoke during the public hearing? When you receive letters? Do you enter those into the
Don't receive
record?
letters. We
Well,
hardly ever get anybody to speak during the
no,
public
but
hearing.
it's because oftentimes, someone might, if they couldn't attend a meeting, you say, I'm assuming in your notice, you say written comments may be submitted to the clerk's office, by
Yeah.
blah, blah, blah.
Yeah.
So you might get written comments. Those should be entered into the record too.
Okay, so what about when somebody just comments in,
They'll go to your house. and
if we
find
have
what's going on.
2 people in the audience, that's a lot. So,
Mhm.
but even those people's comments should go in the minutes?
Are they talking during the public hearing? And are they
Yeah.
commenting on the application? It should be noted that, yes, that you received comments from Mrs. Smith, who lives at 235 Main, and any minutes.
I would hate to see the minutes from that rate meeting.
They were writing down, remember, because everyone said their name, their address, and that one.
An easy thing to do is have them put a piece of paper here and have them sign in. Like before they speak, say, can you please put your name and address, and just have a sheet for them to fill out.
Yeah, but not before we spoke. We did speak.
Some communities I've worked in have them fill out little cards, so that the chair can call them up individually, but I don't see us having that large of a meeting that we would need to do that. But if you just have a little cheat sheet, and then who's ever taking minutes can just take from that sheet, you know what I mean, and write that in there, it makes it a lot easier.
They'd have to be standing outside if you get that maybe.
Right, let's hope we will.
Yeah.
But yeah, you should definitely make sure that's in your minutes.
I don't believe you can make the public give their name and their addresses though.
You can't?
I don't.
If they wanna speak?
I have to look into that. I'm trying to, there's something that,
How did you record that it was this person that said what then, if they don't?
well, I don't know that they.
You could
have
say
to-
anonymous then
Yeah.
probably,
Yeah.
or unidentified, but it still should be then recorded. I would
I'm
ask.
not sure on that. For some reason, we talked about that.
Okay, but I still feel, I've always been advised that you have to keep a record of who spoke, with me. So if it is anonymous because they don't want to, then that's
This one with the green shirt.
fine. Yeah.
Mrs. Smith,
We refuse to give her
name. She had pigtails, someone with pigtails.
But I've never heard, because at all my meetings, I always have them sign
I could
in.
be wrong. I
Or
will
the
check.
clerk has them sign
And if
in.
I'm wrong, then I will
No, you-
say it
I'm
at our
not.
meeting.
Oops.
Do you have like a checklist, Amy, that communities could use to make sure that everything is covered? Because we're getting into a legal world now. Everybody wants to sue everybody.
Mm-hmm.
And with planning and even with council, you know, you want to make sure you do it right, and the attorney's not always present, and you're not always present, because you guys
Mhm.
both do cost money. Is there like a cheat sheet that, you know, like the chair or the clerk can have to say, yep, public hearing, we did this, 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 and this?
I'm sure there is. And I'm sure communities have created them. I can't think of one offhand, but I definitely work with other planners that work in other places. That's my greatest tool is to just email everybody and say, hey, has anybody made that cheat sheet, and I can see what's out there. I do know that a lot of communities kind of create, two of the communities I work with, because when I've gone through their files, they keep inside of like their file kind of like a flow chart of the process of the application. So the date the application was received, the address, the zoning, the basic information about the application, and then underneath it, it'll say planning commission date, public hearing date, date notices were sent for publication, date notices were published, date notices were mailed, and then you keep the affidavit of mailing in there, and kind of in a way, it's kind of like your checklist, because it has the different things that are in there.
Right.
So that would all be in that
Yeah.
particular file.
Yeah, and it's just like a little, they just staple it to the folder up there.
Right.
Nothing really sophisticated.
Do we already do that, Becky or Michelle?
We already, kinda, on the, there's a spreadsheet made for planning commission for how much money they give us, where all the expenditures are. And there's,
CBA does it as well.
yeah, it's not quite as intense as what she just said, but easy enough to fix.
Okay.
Yeah, it's not, and the one I'm thinking in my community, it's just something really simple they just made, that says that. And I could probably get my hands on that and email it over to you, and you can make it however you want to make it for yourself. But it's nothing, I haven't seen like a formal checklist that everyone uses, but that doesn't mean it's not out. I mean, APA has a lot of tools, and Planning Commissioner's Journal, if you ever heard about them, they kind of have a lot of tools out there too. So there might be something I can do a little digging for you and see what I can find. There are publications
Michelle's right. It's in the Open Meetings Act.
that they have to say anonymous.
You do not have to. The only thing you have to do is be able to prove who you are, just to attend, as a precedent, to attend a public hearing or meeting. So you have to prove, if you're one of the, within the 300 feet,
Mhm.
it does say, no one may be required to register or otherwise provide his or her name or other information at a public meeting.
You have to love a smartphone.
Right. So is that in that book that
It's in the Open Meetings
Okay.
Act.
It's in the act.
that's a good book too to have for your checklist of what you can and kind of can't do too, and what's included to have.
Which one is that?
It's the
Michelle,
open meeting handbook.
Michelle obviously read it, and she must have it.
I learned that at
But
a class I was at.
I think if you look, it'll say though that you have to keep a record too of what happened at the the meeting. So you could put anonymous, I guess. I've just never had that come up, to be honest, in any other community, or anybody say they don't want their name on it.
Oh, I actually
Oh,
had
yeah,
it here.
Really?
Yeah.
She wouldn't even sign in.
Yeah.
Hmm.
Yeah,
Interesting.
Not
me,
that
then-
everybody doesn't know.
I don't know if I weigh those comments heavily.
One more quick question for you. How long was the statute of limitations on somebody suing the village if we denied them or we did something wrong? Is there a statute?
I don't, you'd have to ask your attorney on that. I don't know. I honestly don't know that. Now there is, so say if you rezone, if you deny a rezoning or you approve a rezoning, there is a certain amount of time for a referendum to be issued by the public, to challenge that rezoning that you may have approved.
Okay.
And again, I should probably know that, I could look it up, but that does have specific
Right.
time frames and timelines in there for them to get the signatures of the voters and so forth to appeal there and then have it on the ballot. But in terms of a denial and applicant's right to appeal, I don't know that.
I was just wondering, like, for record retention too, if you had all that detail in a folder, at what point can the clerk discard it? And I don't know what your
I don't think
rules
you can
are.
discard
so-
it ever.
Yeah,
You
we
would
don't,
never
yeah,
discard
we
it,
don't.
period?
Mm,
Okay.
No.
No, we're about to get cited by the fire department.
Yeah. We need to buy a storage facility.
Yeah.
Well, and that's, and you know, some communities have gone and scanned in some of the stuff, but that's an expensive overhaul to try to scan in some of those things too.
It is a very expensive overhaul.
Now, some communities have also done is require that the site plan be submitted on disk so that you don't have to keep the paper copy, you know, you can keep the disk of the site plan. You know, that takes up a lot, the site plan doesn't take up a lot of space on your drawer. That's just something to think about, requiring to submit hard copies in the disk.
No, we're fine with space. I mean, we're okay. I don't want the public to, you know,
Ceiling's not ready to
we
fall in
really
yet.
don't. We're doing fine.
Okay.
Okay, so I kind of
So-
interject here.
Yeah.
We're about halfway through our sheet, so if we could kind of streamline our conversations a little bit and let Amy
Right.
proceed.
So talking about site plans, which is again, obviously we know that that's different from your special land uses, but with the special land use, you do have to have a site plan. Statute requires that special land use approval have a plan with your special land use. But your zoning ordinance requirement, when you're looking at a site plan, obviously you have to look at the uses that require site plan approval, the standards for your decision, who is the body that's responsible for reviewing and approving it, and that is all spelled out in your zoning ordinance, whether you know it or not. You want to make sure, again, this goes back to having a complete application and having things spelled out on the plan, because this becomes the document long after we're all gone that you go back to see what was approved on this site. So you want to make sure it includes clearly what is parking, how many spaces, where landscaping goes, where the building's footprint is, all of that good stuff. Because like I said, long after we're gone, this is what they're going to pull out and this is what we're going to be able to enforce. So when we're looking at a site plan, your guidelines are all the review standards met? You have in your ordinance, whether you know it or not, site plan review standards that you need to look at. And some of the things are in there: does it provide adequate landscaping, parking, screening? Does the building meet the area height and bulk requirements? Changes can only be made to the site plan when with the mutual consent of the community and the applicant, meaning the applicant can't just go and change something when they're out in the field without coming to the community first because they found a utility or a utility was interfering with what they wanted to do. That's fine, we can modify it, but they have to submit those revised plans reflecting that modification to the community and get it approved with whatever process it has to go through depending on the extent of revision in the village. If a site has not completed construction, I think ours might be
A year.
a year. If they haven't come in and got a permit within, they might not be completed, but if they haven't gotten a permit within a year, then the site plan approval becomes null and void essentially, and they would have to go back through the process that they got their original approval for, unless you granted an extension, which we have the standards for that in the ordinance. But you know, often I think, how many extensions can we grant? 2? I can't remember here. But there's usually a limit on how many extensions we can grant before then they have to come back. And the purpose of that too is, let's just say we did allow 2 extensions. So 1 year passed, then we granted it another year, and then another year. That's 3 years. Within that time frame, stuff might have happened around that particular site. We may have developed new zoning ordinance regulations that they should be complying with. So, you know, the reason that we only extend site plan approval for so long is so that if we do, by chance, change our regulations or circumstances surrounding the property have changed, we have the opportunity to review it again and make sure it complies with our standards. And again, if it meets the standards, approval must be given. A site plan that's not a special use is not discretionary. That is pretty much a straightforward thing. Nonconformities is another hot topic that I always seem to get into with my planning commissions and building officials and everybody on what is considered a nonconformity and what can we do with these sites and buildings and uses. A nonconformity is often called grandfathered. You know, they're grandfathered in because they were there before. First, I would like to say that oftentimes the term grandfather is used incorrectly. A nonconformity is something that was legally established under previous zoning regulations. So when they went in, they complied with the ordinance, they complied with the site development standards, everything for that use. And since that time, the ordinance either got amended, or the road got widened and their front yard setback got reduced, or it predated zoning. It might not have even had zoning in place. Some people like to throw out the term grandfathering for stuff that is illegal. You know, it might have been there for a long time, but it didn't comply with our regulations at any period of time whenever we had them. Those are different. And not, you know, if you have a use in there that's illegal, you know, you do not have to allow it to continue to stay like you do in nonconformity. If you have a building or a deck that was built on a house illegally, you do not have to allow it to stay. You know, some communities have made it, and I'm not saying it's right, not a personal thing, but if someone went and built a deck or a porch on their house that was inconsistent with the regulations, and just because the community didn't notice for a year or two doesn't mean it was grandfathered or non-conforming. It's illegal, and they have to take it down and rebuild it consistent with the ordinance. So there is a difference, in that word sometimes gets thrown out there when it's not necessarily applying to the same thing. So the big thing with nonconformities is it was legal at one time, and then for some reason the regulations they don't no longer comply with. So you have three types. You have buildings, uses, and lots that are non-conforming. And each type in our ordinance, you will see, has different regulations and things to consider. Buildings, non-conforming buildings, the issues often associated with those are when they want to do an expansion or an enlargement or an extension of that building. Often it's permitted, but the expansion or extension or enlargement has to comply with the ordinance. You can't exacerbate the problem that's out there right now. They can do alterations to decrease the nonconformity. They can extend along the same line if it's not making the setback worse. Rebuilding is only permitted based on the standards of the ordinance to the extent that whatever was destroyed, if it meets the criteria in the ordinance. And maintenance, oftentimes maintenance and safety improvements are associated with things like signs. They can improve them, but they can't replace them. Refix the wiring or what have you. Uses of land would be like what we talked about if you had an industrial use in a commercial area. The expansion and enlargement of those uses are not typically permitted, or are only permitted if you have specific requirements in the ordinance. There are limitations on size, meaning that oftentimes it can stay and do exactly what it's doing in the particular part of the building, but it cannot be extended to occupy more of a building or to occupy a different part of the lot. It needs to stay where it is right now. The duration of the use, or discontinuance or abandonment, is another issue. If the use ceases to exist for whatever period of time we have specified in our ordinance, it's usually a year. It might be, some communities are 6 months, some are 18 months. But if it has discontinued or been abandoned for that period of time, it cannot come back. Whatever goes back in that building has to comply with the current regulations of the ordinance. A change in occupancy, and this kind of goes back to what we were talking about before, does not equal a change of use or discontinuance. So if everything's the same, just the only thing that's changed is the title and the paperwork on that, they can continue to operate that non-conforming use on a piece of property. And that's in statute, this is all statute related as well, as well as case law. With abandonment, there has to be an intent to abandon as well. And this means, and oftentimes you'll get challenged, but the courts like to see, that they've been unoccupied for a period of time, whatever you've specified, like I said, typically a 6 to 12 month time frame, but also that there's been removal, it's not being actively looked to be reused. There's been utilities that have been shut off, postal service has not been continued to the site, signs have been removed. If they haven't, intended to abandon the building, oftentimes it kind of gets into a little bit of muddy water whether or not we actually can allow them to re-exist. So you make sure that we keep a track of, on these issues where we're going to enforce this, you know, the utility shut-off information, have they turned off the water, has trash stopped getting collected, has it fallen into disrepair? And keeping a good record at this village level will help make us have more of a defensible case, again, in eliminating that use and not allowing that same use to go back into that property. Like I said, no use change unless it's to a permitted use. Often, the removal and destruction is associated with how much it exceeds the SEV of the property. So if they cannot, typically they cannot restore a building if it was burned or destroyed otherwise, unless, if only a portion of it was destroyed, oftentimes they can reconstruct, but if it was more than what it would cost to rebuild that building or what its value is, then they couldn't come back either.
What if the building is just being rebuilt and there was really no damage other than just age?
Then I don't know. That's probably, well, was it abandoned for a period of time? Like, what do you mean? How did it not get maintained?
It's just kind of, say, an example would be an older couple lived in a house.
Mhm.
You know, they're in their 70s and 80 years old. They don't take care of the house like somebody that's 30 or 40 or 50 would. So, you know, you're in the, so, you know, they let the building go. So then now the new owner went and bought the building, but it's a non-conforming building
But it's the use is conforming, like the house is allowed in the district?
The use is conforming, but the site is not.
The lot is too small or something?
Lot too small, there's no parking. What do you do?
That's a really good question, and it's been occupied the whole time.
Well, no, it was for sale for a while, so it was unoccupied, but not for a long period of time.
And a non-conforming structure in a district, if the structure does not meet the setback requirements, so I'm just kind of going,
Right.
can be used for anything that's permitted in the district as long as it doesn't change what those non-conformity aspects are. You know, they're not changing their setbacks. A use, if it's a non-conforming use,
Well, the use was good, it's, didn't conform to setbacks, didn't conform to parking, didn't conform to most of the dimensional standards.
it can be reused for, you know, something that's permitted in the district, you know,
Okay.
that use that's permitted in the district. But it should be brought into compliance as much as possible. So, things like, if it's a dirt parking lot and now we require it to be
Okay.
paved, I'm just saying,
Yeah, sure.
you know, you can make it be paved. But the building itself, you can't obviously make that be moved. It can be used for,
But you can allow it to be rebuilt.
you built or repaired.
Well, rebuilt and repaired are basically the same terms, so.
When I say rebuilt, I mean it's destroyed, like you know, the house was, if the walls have stayed and they're not changing the walls, they're just working with the interior, no?
Took the outside of the walls off, put new walls in, redoing.
Ooh,
So a major rebuild, not a structural rebuild, not just a cosmetic rebuild.
it sounds like that may not have been something that's permissible.
Okay, so now
But again, I'm saying,
okay.
that's based on the facts that I've heard.
Sure, and
Right.
understood, but now you've made that property, you greatly devalued that property.
Well, because they're limited on what they can do there.
So you could only use that building without rebuilding it?
You
So-
mean without, yeah, like,
Okay.
if they took off walls and put up new walls,
Uh-huh.
and
Well,
essentially it's a new
the
building,
studs were there, but they took the inside and the outside of the walls off.
to me that sounds like rebuilding, it's not repair.
Correct.
They-
Yeah, it is, yeah.
They allow it in most communities, just what you just said. I run into it all the time. Sometimes they'll just leave a corner of a house,
Uh-huh.
and then they'll build in the same footprint and it's allowed. You know, so it can completely be,
But I would also say that each community is different in terms of,
Yeah,
you
it's
can craft
different.
your
Yeah, but
regulations for
I could understand
nonconformities.
that, but what we're talking about is a non-conformity, not something that's conformed to the criteria.
well, they don't conform, they're not conforming.
Oh,
They're grandfathered non-conforming,
uh-huh.
and if they're damaged or destroyed, usually, most of the communities I work with, it's 50%.
Correct, it is in Armada too.
Yeah,
But
then they
we
can't
allow a
rebuild.
building to be rebuilt after with
But this is
over
different.
50%.
This is different. If you tear like your house down and just leave a little corner, you can build on that same footprint in almost every community I
Right.
deal with. You
Yeah.
know.
Wouldn't it depend on what the building application or the building permit said?
They can't really stop you from doing it because that's an existing house.
And I've heard that too. The apple orchard, when they burned down way back in the 80s or whatever, 70s, 80s, they couldn't rebuild other than what the foundation was. But they could rebuild on the same foundation, but they couldn't expand
Yeah,
on
as long as that
foundation.
foundation's still there and it's usable, yeah.
Okay.
That's usually the way.
Here's where it gets a little tricky to say this community allows that and that community allows that. Each
Right.
community can craft how they
Whatever they
want
wanna
to
do.
treat non-conforming uses in the community. Generally speaking, it's the community's intent to get rid of non-conformities.
Right.
Because
Understood.
if you wanted these to be there, you would have regulations that allowed them to be there. You know, you would allow the lesser of a setback or the whatever else it might be, that use in that district or, you know, that smaller sized lot. But we don't because that's not what we want in the community. So the purpose is to eventually get rid of all of these uses, lots, or buildings in a community. How you do that in each community is different, and how flexible a community or strict a community is with nonconformities is different. Generally speaking, some communities have different classes of nonconformities you could do. You can have a Class A nonconformity and a Class B nonconformity, and a Class A would be allowed to do certain things that maybe a Class B wouldn't be allowed. So some communities treat things that way. It is really kind of all different. To allow a non-conforming building to be taken down and then rebuilt in the same spot, to me, is against what we're trying to achieve with non-conformities. You know, it's just,
Yeah.
it's gonna allow it to be there for
Well,
another 50 years.
It
when our
depends,
point
it
is to
depends on
get
what the
rid of it.
nonconformity is. If the nonconformity is the use, you know, if they want retail going in that area, that's one thing. But sometimes it's just, the house is taking up 90% of the lot, and you're only allowed 75% or something like that. You know, that's kind of a different thing. That's where I see it all the time, where people tear down a house, leave a corner, and build on the same footprint. You know, it's still residential. They haven't changed it from residential.
Right.
The
It's just a non-conforming
nonconformity
building.
is, yeah,
Now, sometimes what happens though too is a variance may be granted for some of those things, and that takes away the whole nonconformity thing too. If they were given a variance to go from 90, you know, to allow 90% coverage, then it's conforming. You know, it's no longer considered non-conforming if the variance was granted. And in a lot of cases, that's what happens. They go to the ZBA and get a variance from some of those things.
So if the village was to be hardcore and strict and say, okay, it's non-conforming, we're not gonna let you rebuild this. You can occupy it as is, but we're not gonna issue you a building permit to rebuild and rejuvenate the structure. So then where does the village stand? Is there any recourse where the property owner can come back on the village and say, okay, you have devalued my property?
Well, their first recourse is the zoning board of appeals. To go to the zoning board of appeals and appeal the decision and request a variance from, either appeal the decision that they feel the decision was wrong, or they could request a variance from those requirements that they are not able to meet. So that's their first course as an applicant to go through. After that, could they say, anybody can say anything. You know,
Sure.
you've
Understood.
devalued my property or what have you, but they would have to prove that. You know, and I don't know if whether or not by you saying they can't rebuild, you've devalued their property. They still are zoned a certain district, and they're still allowed to do everything that's permitted in that district. We don't have to give them the highest and best use on the property. They just have to be able to use their property at a reasonable use of their property.
And not allow them to rebuild?
Again, that's up to, you know, how we want to handle it as a community, but typically, if the intent, just if you think about it, if the intent of a nonconformity is because it doesn't meet our requirements and we want to get rid of these, why would we let them rebuild? That's
So then, at that point in time, then the building inspector needs to be more attuned of what's going on.
Often in a lot of communities, yes. The other thing is, we do allow normal maintenance and repair. So if a non-conforming building needed new windows, that's something that could be a new roof, new wiring, what have you. But to build a new building is something different. To me, it definitely is different. And
New
I
walls
think
inside and out, new wiring, new plumbing.
seems more than normal maintenance for the building.
Okay.
Statute also allows you, as a community, to purchase and condemn non-conforming properties.
It all went bad at one time.
So I would just let you know that too. Again, with the whole purpose of removing things. Non-conforming lots are those lots that are smaller, that don't meet our lot area requirements. They're often at the ZBA for variances. I'm going to quickly go through some of these things. The non-conforming lots, we typically allow them to build on if they can meet all the requirements of the district. Even though they might be smaller, you can still, if they can meet the setbacks and so forth, they're typically allowed to be built on. But they may need to go to the ZBA if they can't. And then they have to prove their case there. The ZBA essentially does interpretations, appeals, variances, and they deal a lot with nonconformities. They will review administrative appeals, meaning a planning commission's decision or the building official's decision. They can be appealed to the zoning board of appeals. Decisions that have already been made, obviously. Action is limited to determine if the decision was properly made or not. So the ZBA is going to say yes, the zoning official was right, or the building official was right in issuing this permit or not. And then that's all that they're going to make the decision on. It's not a variance at that point. This is just an appeal of the decision. They are only allowed to look at special land uses and plan development if they are allowed in the ordinance. And if I remember correctly, we do not allow them to change the special land use and plan development decisions in the ordinance, so that your applicant's course of action would be court. They don't have the ability to go to the ZBA. Text interpretations. If there's a question on what is meant in the zoning ordinance and what the interpretation is, that is a role that should be the ZBA. The ZBA has that role by statute. Same with map interpretations. If you have a question where the line was for a zoning district or what have you, that's this board. When doing those interpretations, they should look at a history of how that language was implemented or used in the past. Look at their records. The benefit of doubt oftentimes goes to the applicant, whether or not we agree with that. But if it's unclear and the applicant has proven that, then often, they often receive the benefit in that. One thing I would point out about an ordinance interpretation, a text interpretation, that then becomes what the ordinance means. So if the ZBA makes an interpretation of the ordinance, you need to attach it to your ordinance because that is how you should be applying it in the future. And then there could be a future amendment that you might need to make. We have two types of variances: non-use, setbacks, height, parking, landscaping, whatever it might be. Variances, they need to prove a practical difficulty with a non-use variance. So the applicant needs to come in and state to you, as to the ZBA, what their practical difficulty is, what it is about their particular site that makes it impossible for them to comply with this requirement of the ordinance. It cannot be because it costs too much money, or just because they want a bigger building, or because they want something self-created. It has to be something wrong with the land. Steep slope. There may be a drain running through it. Something that was not self-created by them, not just because we want it kind of situation, or because we want to make the most money, or have the most intensity on this site. A use variance is another tricky one that don't usually happen in a lot of communities, but it allows a use not otherwise listed in a district. In this case, they don't have to prove a practical difficulty, but an unnecessary hardship. Meaning, I am uniquely different in my piece of property, and it is a hardship for me. I cannot comply with any use or any use that's permitted in the district cannot go on my site for whatever reason. I cannot do this, and therefore I need you to let me have this use on a piece of property. So it's not a rezoning, it's just a use variance. The zoning stays the same, but you're allowing them to do something in that district that's not otherwise permitted. But there needs to be something special about that piece of property, and they need to you need to be able to determine that it's an unnecessary hardship, something that they did not place upon themselves, and that is unique to that piece of property that is not applicable to all other pieces of property with their same zoning. This is what I just went over. So with the practical difficulties, unique circumstances, not adversely affect the adjacent property owners. The variance was not self-created. It's the minimum necessary to provide the applicant with relief, meaning they might be asking for 20 feet, but the minimum necessary to provide them with relief from whatever practical difficulty they had on their site is 10 feet. You do not have to give them everything that they're asking for. You know, you need to make sure you're giving them the minimum necessary to whatever practical difficulty they have. The issue that they are asking for a variance for should not be general or recurrent in nature. It should be specific to this piece of property. So if it's something that can be applied to all the properties zoned R1, that's not something we should be granting a variance for. Moreover, that's something the planning commission might want to look at as an amendment to the zoning ordinance to see if that's something we should be allowing. And this is kind of like, if you keep seeing the same application thing come to the ZBA, that's something when you start to looking at an amendment. I think I talked about all these things. The unnecessary hardship for the use variance is circumstances unique to the property. Is the minimum necessary, will not alter or change the character of the area. How many members are on our ZBA here? 5. Okay. You only need 3, and you can have 2 alternates. Is that what you have? 3 with 2 alternates, or
And
do
we
you
have 5 with 1 alternate.
Okay, and that's fine too. But for villages with less than 5,000, you only need 3 by statute, but you can have more. You can have up to 7. A PC member can be on the ZBA. You're not required to be on the ZBA. The member cannot vote on the same application twice. We talked about that earlier. Also, a ZBA member cannot hold another village office. That's something to point out, because you're kind of looked at as a court or a quasi-judicial branch of the...
We have a village council member as a ZBA liaison, correct?
And that can't be.
No, I think you can have that. They can't be chair.
Okay.
Can they vote?
That's a really good
Well,
question.
it
Actually,
says-
I
it
don't
says
know.
here
that-
that ZBA member cannot
Right.
hold another village office.
Right, no, actually, now that I say that, I don't think you can have a council member on your ZBA. So I will double check that, but I am almost positive that you can't have them.
Yeah, we need
Because
to know
again,
that.
here's why. They're the quasi-judicial
Always
branch,
said
and the council is your legislative branch. So it'd be kind of like having your senators on your Supreme Court. You know what I mean? Like, you don't do that.
Oh.
It can be perceived as, you know, a conflict or just an incompatible offices.
What about the liaison that we were talking about though?
Well, liaison, are you a voting member?
He's the chair.
Yeah,
I'm the ZBA chair.
as a
but
planning
I'm-
commissioner, right?
I'm on the planning commission, but we've never had anything that's come up that I'm aware of where I've had to vote twice. And
Well, you can't vote twice, you can only
No.
vote once.
Yeah.
Yeah.
Yeah,
I think the same was true for the planning commission, for the councilman and being the liaison.
yeah, so council, if there's a rezoning, taking action at the planning commission, you mean, and then back,
But
when
I
it's at
think
council?
you said you needed to check into that on whether they can serve.
On the
On the
ZBA.
ZBA.
On the
ZBA is different than.
Oh, okay.
Yep,
So
and by
it's o-
statute, planning commissioner can be on ZBA.
Yeah.
It clearly says that in the statute.
And it's okay for council members to be on planning also.
Right.
Correct. It's just not okay for a council member to be on ZBA. Or you're
She's
gonna
gonna
check
check.
that
We're
out.
gonna look.
Yeah, I'm gonna double check that, but I'm almost positive, I'm thinking of the logic and why we can't do that you can't do that.
Okay.
And I'm thinking of other communities and I don't have that. So, I'm almost 100% positive, but again, I will double check.
Thank
Voting, this is also another thing that comes up a lot of times, is it the majority of the people who are there, or is it the majority of the board, of the total board? And so for appeals and non-use variances, it's a simple majority of the membership. So if you have 5 members and 3 members come, you have a quorum, but all 3 members need to vote for it. You know what I mean? You can't go by the 2-1.
Oh, really?
Right. It's the majority of the membership.
That's just on the ZBA. That's the, not
Right.
planning like that.
Well, for planning, it depends. For our master plan, it's the membership. For your site plan, you can go by simple. You can go by the majority of those present. And for administrative stuff. For a use variance, you need a 2/3 vote. You need a super majority. If somebody came in and asked for a use variance, you need a 2/3 vote. And I guess if you ever had a use variance, I would hope that you would call. Those are kind of another sticky, icky thing that it's hard to handle on your own. And that's kind of what I'm here for, is to help you kind of with those types of issues and, the voting requirements and so forth. ZBAs, I think, are often, and it happens to the planning commission, but I feel like ZBAs get a lot of pressure a lot of times to try to make peace and to try to make a decision that's going to make people happy and resolve a problem with the ordinance and those kind of things. And I guess I often get a lot of pressure from the applicant. They might get their neighbors coming in and saying, I don't have any problem with this fence. I want this fence to be here. We think it's beautiful. And so I guess with the ZBA, don't feel pressure to make decisions based on the public comment.
We've got the checklist we go through. I mean, if it doesn't meet all the criteria on that checklist, then they don't get the variance.
I'm very proud of you for that, because I have a lot of ZBAs that don't do that.
We have
it
one
should be
guy
harder to get one than to get one.
We had one guy come in and said, well, the neighbors all think it's fine. So then, using your logic, sure, I should be able to say people that my neighbor don't mind if you go at 50 miles an hour in a 25 zone.
Right.
It's the same thing.
Right.
If they don't meet the criteria, they just they
That's
don't get the
fantastic.
variance.
I think I have some ZBAs where, unfortunately, people know that they will get their variance and they just go there to do, and they kind of do what they want to do and they go get their variance, and those ZBAs need to be reined in a little bit. But generally speaking, it should be harder to get a variance than, you should have more no's than yeses, because it's very hard to meet those standards. When you look at those standards, it's very hard to meet it. You as a ZBA are not there to solve the problem. You're just there to look at the particular case at hand and to evaluate it based upon those standards that you just talked about. One thing, since you do have a liaison, if you are noticing a problem, is to take it to the planning commission to look at reevaluating the ordinance and what those particular standards are. It's kind of the benefit of having that inter-membership between the two groups. Your duty is to everybody in the community, not just that site and that person, and giving them that variance. You have to remember that what the action you take has ramifications on future applications and to the whole community. As with the planning commission, I always recommend, if it's a long meeting or you're feeling pressured, just table it and bring the application back. I often find it there's might not make the applicant happy, but we want to make sure we make our decisions appropriate. You're bound by the standards of the ordinance. Property owners, again, have certain rights, but they only have certain rights within the limits of our zoning and our authority. Again, everything is related to the land, not the circumstances of the owner. Not that the owner couldn't get a loan to do something, or that they're running out of cash, or that they didn't know they needed a permit and they built it anyway. Yes, you might feel sorry for them, but the rules are the rules and they have to follow. Like I said, it's not the job of the Board of Appeals to help applicants find their way around the ordinance either. It's not your, to give them this variance so that they don't have to meet the criteria. We set the criteria as a planning commission and as a council to implement our vision, if we go back to the whole reason why we do everything. So if you have a ZBA that undermines all of that, it's hard to achieve that vision. You can't, obviously we've talked about this stuff. As I mentioned earlier, consistency is one of the best things to do. Follow the same rules and procedures, treat everyone fairly and consistently, avoid your conflicts of interest, keep accurate records. These are all things that will help you minimize your liability on your decisions. Everybody has the right to have a reasonable use of their property to help you avoid takings. You cannot totally prohibit a land use in the community if there is a demonstrated need for that land use, but it does not have to be the most profitable land use on a piece of property. So if they can still use their property for something that's permitted in the district, that is not a reason to allow them to do whatever else they might want to do. It doesn't have to be that we make this property owner the most amount of money, because for whatever they might be coming in here to do. If they can do something else in the district, and it is a use that would be profitable and meets a demonstrated need, then they can do that too, and you can say no to the use that they want.
We've been pushed by different planners at different times to have more low-income housing sites available. Now,
Planners from the county? Or-
well, I would, no, it was actually a firm before yours said that we needed to do that.
What do they mean by low income housing? Do you know, like more apartment? Like what, I guess what were they?
Well, a smaller lot, something that would sell, a house on a smaller lot that would sell for less money so that you could, and my thing was, don't necessarily want to have low income housing or to have housing of that nature that, would be not low income housing, but a house with lesser value. Rather keep the house values up rather than take them down.
Well, there's a couple things. You want to make sure you have a range of housing types available in your community, for different life cycles of entry-level housing to, families, to empty nesters, kind of the whole aging in place concept, so you can keep people in your community, for, their whole time, it's from when they get out of school to when they start their family and their kids go to school, all that kind of stuff. So that is a different range of housing. Do you have to have a mobile home park or, all of those kind of things? I would say you do not have to purposely plan for something that's considered low income housing. If you're talking about lot sizes, the village is the place that you do go to for smaller lot sizes in the area because you have the township that surrounds you that is a lot larger, that they have a lot larger requirements for lot sizes. So in that regard, I think you have a strong case that you do offer more affordable housing in that regard because you have, what's our smallest lot size that we have in our
70 by 120.
which is,
So we really don't have, that's our lot size. It's the smallest and largest minimum requirement.
But we also permit in certain areas, like we would permit second-story housing downtown. We would permit, you have your senior housing area over there where they can do more apartment, attached housing types. So I would say you do have that. I would never suggest that you do all the same thing throughout the community, all single family. You do have, there is going to be need for people who are going to need an apartment to rent at some point, possibly in their lives, or senior housing, or what have you. So you don't want to exclude those types of housing, but I don't know if you need to necessarily plan for low income housing, but more or less. The market's going to dictate a lot of your range of housing types too. I mean, if you look at communities like Birmingham, they have lots that are 50-foot wide lots where you're getting $800,000 houses, so it's kind of, the market is going to dictate a lot of whatever. They could try to plan for low income, but that's not,
Not going to happen.
right.
Like we're alone.
Exactly. So the market has a lot to do with that. Unless you own the land as the village, that's the only way you can control really what went on there. Another thing just to quickly go through is conflict of interest. And this comes up a lot with ZBAs, planning commissions, everybody. You must abstain from discussion and from voting if you have a conflict of interest. Or even, I would suggest, a perceived conflict of interest in a case. Conflicts of interest come from typically financial employment. So if your boss is up here presenting an application to you as a body, that is something that I would say you have a conflict of interest in. That is your boss, he controls your livelihood, pays you, what have you. If that's your boss presenting an application that you're voting on, I would disclose that to the commission and then recuse myself. personal, if it's your brother, your sister, your wife, your mom, that's the applicant, again, that's a conflict of interest, because you could be perceived, and if it is a relative like that, you probably are benefiting from whatever application they are presenting to you at that time. If you are the applicant, you should be recusing yourself from the discussion and the voting. Village officials should also, well, first of all, unless you own that property and you're the business owner or something, I strongly discourage a village official from representing an applicant and presenting it to the commission. But village officials, if you are representing the applicant or what have you, you need to then abstain from in front of that body from voting. If that makes sense. Questions on any of that? No. So just to go over, since you guys are now also this wonderful DDA, I'm just going to go over some of the authority. I didn't get into a lot of this because it's my understanding you guys are going to be doing a lot of what a DDA can do, unfortunately. But the DDAs are created, they have their own separate Bible, the Downtown Development Authority Act. Communities with less than 5,000 can designate by ordinance, which I'm assuming you did, your planning commission as your DDA to serve as the board. Now the thing there is you are still two separate boards, and you have different roles and responsibilities. What the DDA Act though does say is that if the board also serves as the planning commission, you have to include, the board has to include the planning commission in its agenda. So I'm not sure why that's in there, but that's right out of statute. So, your agendas should, I would suggest that you have an agenda that says planning commission items, DDA items, or however you want to organize it when you have DDA business. But it should be, obviously they want it on the same agenda for some reason. Again, I don't understand why sometimes legislature write things the way they do.
But then, do we have to keep two separate sets of minutes? So when you open your planning commission meeting and then you get to your DDA agenda or your DDA item, now you kind of create another set of minutes?
I would say you could keep it as the same minutes. This is my suggestion, but you may need to.
We were just told tonight that.
Just do separate?
Our attorney has recommended that we keep them separate.
Okay.
2 sets of minutes.
Then do it separate. I would just say that I would label them because you're not always going to be a planning commission and DDA in the same meeting. You know what I mean? In the same day. But if you want 2 separate minutes, then that's fine.
The way they're kept in the office is separate. I'm planning commission, because as we're a separate board,
Well,
so.
I guess being that way, it would just make it easier.
I have a question though, that part of the act where it says that the planning commission should be included as part of
Yeah, I don't
the
get
DDA's
that.
agenda.
Yeah.
And in that, to me, when you have one agenda, that would be like one set of, minutes.
I think what I would do, and I would check with Jeff, but is just have your DDA meeting first, list your agenda items. I don't know if you can adjourn or not, but adjourn, then do your planning commission, start at this time.
I could kind of recommend that too. In some communities,
That way
we
you have
do,
your 2 separate minutes.
they do kind of 2 separate things. They have public hearings as like a separate part of their agenda. So they open the public hearing, have the public hearing, close the public hearing, then open their regular meeting and do the same thing. So I almost envision it kind of the same way as
So
that.
Well,
we
since
actually
the-
have two meetings in one night.
The DDA business is gonna be so minimal,
Oh, yeah.
that
Oh,
those
yeah.
meetings will only take probably 5 minutes. I would allow for
Yeah.
10, but, yeah, I asked Jeff about that,
Mhm.
after that class I went to in March, because I
Yeah.
heard that we talked about it.
It's in
I
the-
mean,
it's in the-
I would say I would do whatever the attorney does, tells you to do, but if you clearly called them out, it might be okay to do it together
Yeah.
too. Not that a lot of this is going to apply to you, but I just thought I'd give you kind of a background for those of you who might be new to this. But the DDA essentially has several financing options that they have tools available to them. There's the tax increment financing, which I'll go over a little bit, which you guys do. And then there's special assessments. You do have the ability to assess up to 2 mills in a DDA with a community of your size. You can have revenue bonds. You can get revenue from the sale or lease of DDA or property if you had it. Donations and grants can also be given to the authority. The DDA can apply for a grant, just like the city could, or the village could apply for a grant or something like that. There can also be contributions from the village, which it seems like that's where we're going to be getting some funding in the next few years to come.
Quite a bit of funding in the next few years.
But so those are your options to finance the authority. And probably, obviously, the most common are obviously bonds for special projects, which you guys have done, and now we have some issue with our TIF. But special assessments, I believe you guys do not assess your 2 mills in your DDA. Okay.
Council absolutely promised that would not happen. There's a lot of residents that are in that area.
So you,
Like you?
Exactly.
but it is, and just by statute, it is something that some communities do. And then the TIF. Not a lot of DDAs own and sell property or lease property out. Some of the bigger ones, like the Southfield or Detroit or Pontiac, they do have buildings that they do sell out or incubators and stuff like that. I'm not sure of any community of your size that does that kind of thing. And then donation grants and contributions are the other one. But the revenue from the sale and lease of property is less common in communities of your size.
So are there any underwater grants?
None that I'm aware of. You wouldn't be the only community.
Okay, no.
I would say, I don't know, maybe go to the bonding attorney and ask them for the approve it, and ask them for a grant, some of that back. In terms of, just to kind of tell you what a TIF is, and the tax increment financing, essentially what happens is when you create your district, for those, I might be talking to everybody that knows, but I just thought I'd go over it. When you create your district, you establish a base year SEV, or value of property. So then the theory is that property values will increase over time, and there will be investment in the district, and your actual value of your district will increase. So you get to capture those property taxes on that portion that increases, not on the base. The base still goes to everybody else. The base still stays with the village and the county and whoever else. Schools, that's kind of a complicated part, but you only can capture school money as if you captured schools to pay a bond before all proposal A and all that stuff happened. And I don't think there's many communities that still do that actually these days. But, so you just get to capture the taxes on that differential, the increment, the $250,000 in this instance. Taxes that you can capture are essentially all of the state, local, and county property taxes, except for those that go to schools, or those entities that may have opted out in the creation of the DDA. Did we have any that opted out in the creation of the DDA, or did we capture everything here?
We captured it all. We
Yeah.
sent the letters and then we applied to opt out.
I tried.
These days, you'll see communities, Macomb, even Oakland, Wayne, not being willing to participate in new DDAs that are being created. And when the DDA gets created, those entities have the authority to opt out of having their taxes collected. But they only have that option in the very beginning when the DDA is created. And also, right now, there is some pending legislation, and I didn't have a chance to look it up, but many DDAs are capturing the zoo and art millages. Are you guys capturing those?
No, we're not.
No.
No.
There are-
I've heard that.
Yes.
They're doing their.
And so there is legislation being done right now to clarify all of that discrepancy and to exempt those from being captured. But so I, because when those, technically by law, by the DDA, it says you shall collect all of these millages. And when those millages were created, they weren't specifically exempted from that capture. So there's a lot of DDAs kind of around, like by me and Northville, Plymouth has gone through it, where they've been capturing this because they said we're required by law to capture this, and so they've been capturing those millages, and there's been some nasty articles about it saying they're stealing the money, from the animals and art. So again, there's pending legislation to clarify that.
We
So I think
also
they're going to
don't
exempt.
collect on the fire department either.
is it a revenue?
Because it's included.
A revenue millage?
Yeah.
Yeah, a revenue millages as well. So, I should have put that in there, and I'm sorry. But yeah, revenue millages and, well, obviously schools, but anything that was dedicated specifically for revenue is exempt as well. So you guys, really your authority is going to be, I think, how I'm envisioning it, or at least what I've been told, is kind of rubber stamping and just kind of an administrative authority. But you are by statute required to have a budget and adopt a budget. So you need to prepare a budget, or somebody will prepare and present to you a budget that's done the same way as every other village department. And then it gets presented to the council for their approval, and then you adopt that budget. So you'll actually have to adopt a budget every year for paying out your funds and revenue from the village or whatever you're getting. But really, that's probably your only authority. Unless for some reason there's a huge development in town and your tip increased for some reason. The other thing we wanted to talk about quickly is I know there are some projects out there that we're looking at, even in our master plan with on the south end of town, doing an industrial type park or getting some businesses down there, and we've talked about maybe even some new roads on the west end of town. And I kind of wanted to go over with you an approach to how we can get these projects rolling, and you know, people you need, we or you need to start talking to, and how to do it. The approach that we've done here is pretty simple in that we haven't included a lot of TIF kind of related tools, just because I didn't think that was going to be something that was necessarily favorable here, but there are some other tools that I'm not specifically talking about here that may in the future become more appropriate in the discussion. But I think the first thing we need to do is have a clear set of what our goals are here. I think we've talked about it during the master plan process, but it might behoove you guys to come up with council jointly some, you know, what is our goal for economic development? Is it job creation? Is it tax base? Is it, you know, what is it that we're trying to do? Is it supporting our existing businesses? You know, is it retaining our existing businesses? And maybe it's all of them. But we should specifically, I think, identify what those goals are and be able to have them in front of us and to be able to reinforce them as we keep moving on. The next thing we need to do is look at a project, and we either, and I probably should have put it up here, you know, but evaluate public or private sector initiated projects against the goals. So first of all, and this is for me kind of assuming somebody's presenting something to us. So let's say, you know, we have a project coming in and they're asking us for tax abatement, or they're asking us to assist them with a road, or they're asking us for whatever. We want to be able to have some standards and goals in place where we can evaluate that against. Is this project that they're asking us for, these things, going to do A, B, C, and D that we want them to do? You know, help us to not get so excited about a particular project on a case-by-case basis, but, you know, make sure we're looking at it as a big picture. If it is, one of the first things I would suggest that we do is submit it to SEMCOG to be on their SEDS, Comprehensive Economic Development Strategy. SEMCOG does this every 5 years and updates it annually, but this is to get federal funds. In order to have federal funding or be part of having federal funding, you need to be in this strategy. So if we have a project that we like, we need to submit a request to SEMCOG.
Do you have to belong to SEMCOG?
That's a really good question, but I'm going to say I don't think so. I don't think the federal government would make you belong to the COG, but it's another thing I will have to look up exactly. You guys aren't members of SEMCOG?
We are on the sewer end somehow, but I don't think the village as a whole is.
Okay. That's a
It's
good
expensive because we looked into it and it was expensive.
question. No, I know that it is. My gut is telling me no, but I will double check that.
Okay.
But that's like one of the first steps. You know,
I
these are
think
kind
your
of
gut's correct because one of our projects,
I don't see how they
This
can make
came
you
up
pay,
with our engineer.
because I'd be concerned with them making you pay to be eligible for something
Right.
federally funded. I don't know,
Right.
it just doesn't seem right,
Yeah.
but there's sometimes things don't seem right there.
Right.
The next is, again, I would suggest kind of like what we talked about with the other thing is identifying our most important stakeholders for these projects and coming up with the actual project. So if this is for more of the projects we want to do on our own, which I think are the two things that we talked about, is number one, we need to create that project and identify it and put it down on paper and what is it and draw it up. And the big thing about that is making sure that we have funds allocated, from the village is gonna have to wanna make sure they have, I would almost even say this as a project in their budget. If this is something you wanna do, that you allocate funds toward it to make sure that you can continue to work on the project. But then once you got it, go through and make sure you're looking at these projects and look at who do we need to have involved for all of this? Is the school district appropriate? Can they help with funding for anything? Have we talked to everybody in the area? Have we made this project as big as we need it to be? Do we need to add people to it? Property owners, and we've kind of talked about some of this with the road. Is it not just the one site, but there are probably a couple other property owners that we need to get involved? And bring them all to the table, and we want to make sure that even before we go to try to get this financed, that we have a unified plan and project in place. And then, for each stakeholder, we have to kind of work with and ask, sometimes they're not interested in being part of a project. And we kind of have to figure out how do we engage them? How do we make, sell this project to them? So, it's not as easy. It's very intensive, I guess, a lot of people time with people and walking face to face to create the project. And then ultimately decide who's responsible for what in part of this project maybe. So is it the village's responsibility to put the road in, or is it the private sector's, or is it parts of it? How are we going to divide that up? In terms of getting funding for these projects, our big funders are going to be federal, state, and county. And each of them right now kind of have their own, I don't know what to call it, pet project, that they're giving funding out for. Right now, the state has their My Place, and it's all about placemaking. So if you could tie our project to placemaking, or tie the project to how it's going to improve downtown, and so if we build this industrial park, we will be able to relocate these businesses and make downtown a better place and so forth. That might make us more eligible for some of the state programs that are out there. The county's big things are manufacturing, transportation, and agribusiness. Agribusiness might be something that we can sell too in terms of that and getting some of the county's programs involved. The federal money with the SEDS are related to sustainability. So you kind of have to figure out, once we get this project on place, how we sell it to each of these constituencies. But for the most part, we have to have the project on paper and a plan is the first thing. I would say that's our biggest first step, is having these projects more than just something that's in our minds. And then for the road projects, the other thing we have to start talking to is the road commission, SEMCOG, and getting on everyone's TIP plan. And I don't know if you have representatives that go to those meetings, but getting your project into one of those plans will definitely help getting funding from those. If they're not in those plans, our chances of having it funded or getting their help getting it funded are kind of slim to none. So there's a lot of advocating that has to be done, but the biggest thing, like I said, for us is to get a concrete plan that we could go out there and advocate to get into these other plans and start applying for the financing. And that's kind of, in a nutshell, that's kind of it. I mean, the preliminary project concepts. We've kind of talked about this, having what is it that we're going to go out there and have to try to figure out that we have to build. Do we have some rough land costs and budget and estimate on what it'll take to get it done? And then once we have that, we can kind of frame it around those other facets of the project.
Steve, you got a question?
Well, you say we need a plan, as in drawings and designs.
It doesn't have to be deep, I mean, it doesn't have to be like an engineer.
Okay, that's the question I have, because you're gonna have
Cost.
quite a bit of cost involved.
Yeah.
And you're asking for money anyway, now you're doing this, it's just an idea thing,
Mhm.
and you're throwing money out there, hoping that they'll like it and give you some money in turn, but
Well, and
you're
that's.
more talking a concept.
Exactly, and there is going to be money on the villages end that has to get put up for a concept. I mean, you do have to be able to have you have to be able to have this concept be relatively viable, you know. So you need some survey information. You need to know what is actually, you know, going to be able to happen on the property. The EDA is, you know, they do offer planning grants. You know, so if your project gets included in SEDS and all that, some of that can be for planning. You know, some of the money you can get for some of these projects is for planning. But it has to be projects that meet those, you know, kind of their issues right now. And the other thing is, these projects often take more than a year, you know. Political climate changes, so we have to stay on top of kind of what it is we're trying to focus this project around to get that funding. You know, so you have to kind of keep someone on top of that, making sure that, is the EDA still focusing on sustainability? Is that what we're looking at? Or have they totally changed their direction and their projects are now going to something else? You know, we don't want to be going down one avenue and then end up having to, you know, realize it's not going to work. So it's something that kind of evolves. I can say that one project that we worked on in Buena Vista Township, and it's been going on now for probably close to 10 years, is they had an abandoned mall there. And we worked, I mean, it was a long process, but it was, one, doing a market study and coming up with a vision for what we wanted it to be. So what was our project there? And then two, you know, they had to go through, the first phase was to acquire that land. You know, the township needed to acquire that land. So what that entailed was, they first tried to talk to the property owners to sell it. They didn't want to do that. Then they went through the condemnation process and trying to acquire it that way. And finally, they did end up buying the land from the property owner. But what they ended up having to do, you know, like I said, it's a multi-year process, and funds, you know, it costs a lot of money up front to even get to the point where they are now working with, they've had, I think they had $600,000 allocated for road improvements now that they have acquired the mall and the mall is down, and they're going to be doing they have some public land they're going to be doing park improvements for, and they worked with the local community college to do a satellite office now on that property, and they did get a new restaurant there too. But it's taking years. I mean, I'm not trying to discourage, but it's just kind of how it works, of taking that project and implementing it piece by piece. But it requires someone to stay on top of it, or hire someone for us to stay on top of it. And I'll just be honest, it's a very expensive thing to have somebody else do it for you. In there, I couldn't even tell you right now how much that has cost them to have us do it. But the benefit of that is that they have no longer this abandoned eyesore right in the middle of their community, this, you know, 1 million square foot mall. They have that taken down. They have a new community college coming, a new park, you know, new streetscape and road improvements. You know, they've gotten what they wanted. But it all started with the plan that we could go shop around to get people to help us with the funding and the financing of that. So, I think that is pretty much it. I mean, this is just, like I said, one champion, you know, for the project. You have to have it make sense for both the public and the private sectors, too. I didn't mention that, but.
So, again, you said something about county, state, and federal. With the county kind of like agriculture, what's the state and federal?
The state right now, you probably read a lot about their My Place initiative. A lot of it is placemaking. Placemaking, neighborhood focused, improving housing is a lot of their stuff that's coming through. So if we could, I think for our projects, if we could tie it into how it will improve our downtown. You know, a lot of their placemaking is dealing with downtowns too, and how that makes Armada a better place, you know, to live, work, play. It would make us more enticing to the programs that they have out there right now. The EDA, a lot about it is about sustainability. They have a lot of money for environmental stuff. They have, you know, if we could show how this would make us more sustainable in the long run, I think we can tie sustainability though back to placemaking, in that if we can make our downtown healthier by relocating some businesses or having area available for some of those businesses to relocate, I think you can make an argument that that would make us more sustainable and people wanting to invest in our downtown and live here and shop here and do those kind of things. So I think you can make arguments for it, but the first place I think I would go is probably the state and the county. The federal government is usually the last one to the table, you know, in terms of a project and getting money from them. And I'm not sure with the road project and that, how big of a scale it'll actually be, you know what I mean? Jobs is gonna create, tax base is gonna create, that it would even get their interest, just to be honest. I don't know if we're big enough. But, I mean, there's still an option. But they're gonna look at those things, you know, how many jobs.
And it would create jobs, but I don't think, like you said, I don't know.
Right.
I don't think any of our projects, the road on the south end of town, with the elevator and the industrial, that would create jobs, but I don't know if that would be enough either.
It might not be enough for federal, but we might, there's still the county and the county's programs and some of,
So is there any money that's maybe available for the parking lot that's we're trying to get, that was a automotive repair facility, and now it's not vacant but being used, but it's available?
is it a brownfield? Is it, have you talked to the county about doing brownfield? And I mean, that's getting into TIF and stuff there too, but they usually, that might be an option for that site.
But if you declare it a brownfield, now you really want to make sure that it's going to happen.
That there's a project.
Yeah.
There has to be there has to be that project. Other than that, something specific? No. I mean, the other great tool you have,
I mean, that would
Just talk
really
to
make
your-
the downtown sustainable. I mean,
talk to your state reps, you know, and
Oh,
your local
okay.
politicians, and you know, just get your projects in their ears, and you know,
First post.
you never know what they might be able to get for you too.
okay.
We need to hold down a
Never hurts.
brownfield to get the DDA and all that
Do that.
in the first place.
Did it blighted.
Yeah, which that's the part.
Okay, is there any more questions before we get too crazy with sidebars? Is there any more questions for Amy?
No.
Good, okay.
Great.
Well, I want to thank you, Amy. I thought this was
Yeah,
very good, very
Good.
informative.